Court of Appeals State of Michigan following session. The Honorable Mark T. Boonstra, the Honorable Annika Ledica, and presiding Honorable Christopher M. Travilka. All persons having business here and draw near, give attention and shall be heard. God save the United States, State of Michigan, the court, please be seated.
Good morning, everyone. Yeah, full house today and a full docket. My name is Chris Travilcock. I'm serving as a presiding judge for today's panel, and I'm joined, as you heard, by my colleagues, Judge Ledica and Judge Boonstra. We welcome you to the first day of our April 26th Lansing case call panel, panel number 4. Just some preliminary comments and thoughts for everyone, for both the general public as well as the attorneys that are going to appear before us today. We recognize that these cases are important to both the litigants and counsel, all of you that are here today. And often our decisions are the final word on the dispute or problem that gives rise to each case. Now, I can assure you that we all here on the panel and our staffs have been working diligently on each case. And we have had the benefit of all the briefs that have been submitted and the trial record in the case below. We have a very full schedule, and I do want to cover some ground rules for everybody. First, each party is allotted time for oral argument as provided in the court rules. Second, if there's more than one attorney on each side, please let me know how you are going to divide your time of argument so we can make note of that. Third, for the appellant, let me know at the beginning if you want to reserve time for rebuttal, and we will do our best to help you keep track of that time for rebuttal. The fourth and final rule is that if your case involves children, sexual assault, or other sensitive topics, please do not mention the parties or the child's name or names. Instead, refer to them by initials or other private identifiers. Today is being recorded. You probably heard that when Juan turned that on earlier. This is recorded and will be broadcast on the Court of Appeals YouTube site and available to the public later today. My last comment before we call the first case is my advice based on over 23 years of practice before this court and my time on the bench. And my advice is this: we're very familiar with the relevant facts and pertinent case law involved with your case. My best advice, and I highly recommend to focus your limited time on the specific issues that are dispositive of the outcome here today, and to address specifically any of the questions that we may ask you, because if we're asking them, we're not just doing it for fun. It really matters and is determinative to the outcome. So please do that. With that, which is a little anticlimactic, we're going to call our first case, which one of the attorneys has waived oral argument. And that case is case number 1, case number 374525, People of Michigan v. Zolman. Briefs have been filed, and appellant was preserved oral argument, but it has a waived oral argument. Therefore, that case will be submitted on the briefs. Now calling docket number 2, case number 378071, People of Michigan v. Wills III. Counsel, please approach. And if you would, please state your appearances for the record.
Janet McLaren on behalf of the people.
Good morning, John Toast on behalf of the appellant.
Thank you. You may proceed.
Thank you. We are requesting a published opinion in this case because we believe that this is that imperative due to the importance of ensuring that impermissible character inferences are not allowed by the court forcing a witness to appear, and in this case it was a victim witness, to appear in jail garb where they are in jail on a totally unrelated matter. We believe this would only serve to confuse the jury and allow them to infer that the victim is a bad person and less credible in exchange for no probative value. The jury would find nothing bolstering or preferential about a witness testifying in civilian clothing, but a witness in jail garb would raise jury confusion and impermissible issues of bad character. This court should enter an order reversing the trial court's decision. And I have nothing further unless there's questions.
Trial court seems to think this is the practice in Genesee. Is that right? Or I
It
gather
is
you disagree
not.
with that?
I think that there are often times when we have a testifying co-defendant, which is more often the case than that we have a witness who is in jail. A testifying co-defendant, I think it is our practice, not always, but generally, to keep them in jail guard because we are explaining to the jury that they're getting something in exchange for this testimony, that they are a co-defendant. And of course, by law, we have to tell them what their plea agreement is. So they're already being told that this witness was arrested, is part of the criminal activity, and it isn't the same thing as when you have, where this court has already ruled in this case, that nothing that happened in the case for which he was arrested, or the child supporter case, or any of that is coming in because it was not probative of anything.
Is there, to follow up on Judge Winster's question, is it more than a practice? Is there like an IOP at the Genesee Circuit Court that you're aware of?
No.
Or any written policy? It's just sort of
No.
a practice and maybe poorly reflected by the trial court judge?
I think so. And as I stated, I to show my age, I've been doing this almost 30 years. I've done probably more trials than anybody that is currently employed at our place. And I have seen it done. I think I stated two examples, one an older case and one a newer case. It's not a policy that I'm aware of in any way, shape, or form by either the prosecutor's office or the court.
So you filed a motion in this case about the mootness.
Yes.
Want to address that for us?
Thank you. I would like to do that. I believe this is not moot for two reasons. First of all, well, actually for three. I don't know if this victim witness could be put back in jeopardy of going back to jail again because he's not off. My understanding, I could be wrong, but my understanding is he's not off out of the woods yet in terms of probation. Secondly, we currently have another witness who, after we brought this motion, after we brought this appeal, went into jail as well. And he is currently, I just checked on Friday, he was currently in jail as of Friday. So I don't see why this would be an issue that would be ruled on any differently by this judge. And thirdly, I think the statements that the court made it clear that he believed that we should never be allowed to do this, that he didn't go that far, but I think the statements that he made it clear that he believed this was a policy, that he believed that he would make it his own policy. And I don't think that that should be the rule here.
Is this issue capable of repetition yet evading appellate review?
Yes.
Why so?
Because again, what happened here in this case could happen again. Most times these come up, as it did here, right before trial. And if he continues to rule this, that prosecutor, you're not putting your witness in civilian clothing, then we'll be in the same position that we're in right now, where we had to bring an interlocutory. We asked him to stay, he would not. And we had to intervene to ask that these things happen for this witness. I don't expect it would be any different for any other. I can't envision a scenario where it would be different. That's our perspective.
Does the informal policy have anything to do with that perspective?
You mean the judge's
the
informal
court's
policy?
Yes, the court's policy of never allowing it.
Yes, I think it does, because if it's going to be repeated, which I believe it will be, again and again, every time the prosecution wants to put a witness that might happen to be in jail on an unrelated matter in civilian clothing, to avoid this prejudicial aspect of the jury wondering, why is this person in jail, or thinking they might be less credible because they are in jail, then I think that that's repetitive, yes.
Any other questions? No. Thank you, counsel. You have ample time for rebuttal
Thank you.
should you need it. Counsel?
Morning, may it please the court. Incarcerated crime victim testifying as witness does not have a right to dress in street clothes, while criminal defendants have a constitutional right to appear in civilian clothing to preserve the presumption of innocence. That protection does not apply to witnesses.
Isn't the issue really not a protection, but what it does to credibility? And doesn't the credibility of witness matter just as much as, the presumption of innocence or guilt for a defendant?
Well, there's no constitutional right for a witness to appear credible. And our position is that our trial court judge maintains broad discretion over the courtroom decorum and the appearance of witnesses. A prosecutor may request a victim witness to be allowed to wear street clothes to improve their credibility or appearance before a jury, but this is a matter of court permission and logistics rather than a guaranteed right. I don't believe there's any abuse of discretion on the part of the court here. And as far as this witness
Does
is
the court
classified as a
Does the
victim.
court recognize that discretion in this case?
I think it does implicitly. It's a very, and I've been practicing in Genesee County for about 27 years. The trial court judge was a prosecutor prior in the Genesee County Prosecutor's Office, who I've tried cases with prior to taking the bench, and he's been on the bench for 3 or 4 years. And contrary to what counsel indicated in their brief, that this judge didn't have a lot of experience on the bench, but he does, and he's got a lot of prior experience as a prosecutor. I believe he understands, he has the ability to make decisions. This is never asked. I've been doing this for a long time. I have never had a case, and I've discussed this case with a lot of colleagues in the criminal defense bar of Genesee County. Witnesses don't get dressed. It just doesn't happen. And for this court to say, well, this one gets to, if Judge Hannibal ruled that way, he's bolstering the prosecution's witness. You take the witness as you find him.
So, but if he was, so now that he's out, the order's still in effect. Are you suggesting that he would need to appear in jail garb?
Absolutely not. Absolutely not, Judge, Your Honor. Perhaps there's a chance that he goes back to jail because he's on probation. It's my understanding. And the reason he was in jail wasn't because he was charged. The reason he was in jail is because he egregiously violated his bond. He chose that. And that was while this case was pending. He was he was the so-called victim. And so if he makes those decisions, well, why would this witness, who happened to be a police officer who was terminated, and why does he get special status? Other testifying witnesses, co-defendants, snitches, they don't get to dress ever. It's not even considered ever. And in my career in Genesee County and other counties, I do practice in other counties, I've never encountered a situation where a witness was dressed ever. The Crime Victims' Rights Act does not have a provision for victim witnesses. You get to dress because you're classified as a victim. If the legislature wanted that, I assume they would have put it in the Crime Victims' Rights Act, but it's not there. Courts have broad discretion. This is not abuse of discretion. This is not an abuse of discretion. That's our position. And I'd ask that you affirm the trial court.
Any questions? Thank you.
Thank you.
Councilman Zepelin.
Thank you. I would just argue that there's really no special treatment here and no bolstering. As we stated, the jury would never know that he was in jail. So I don't understand how this could possibly be, or how the trial court found this would bolster our witness. It would be different if they knew he was in jail and they say, oh, and by the way, we're giving him special treatment, which I don't think this is, of letting him dress for this. The jury will never know any of this. And that's the whole point why the court wouldn't let it come in the first place, is because it's not probative of anything. I don't think it's special treatment because, again, yes, we often do not dress our witnesses. If I had a testifying co-defendant witness, I did not dress that witness because he was a co-defendant, and I was telling the jury exactly why he is in jail garb and exactly why he's getting a deal in exchange for his testimony, as we are required to do under the law. But in this case, all it would do is serve to confuse the jury. It would serve to prejudice the prosecution and be an inference that that witness is not credible, and it simply isn't allowed.
Any further questions?
Thank
Thank you,
you.
counsel. That case will be submitted. Moving to the next item, docket number 3, case number 369710, People v. Joshua Leonard Cano. Council, please state your appearances for the record. Thank you. You may proceed.
Thank you, Your Honor. I don't really have much to say today. I will concede, as Ms. Wilson and I have talked beforehand, Mr. Cano has since been paroled, so I think that the issues in this case are largely, there's not much to discuss. I'll just present myself for questions and be happy to take any.
Any
No
questions?
No questions.
Glad the bridge opened
Oh, yes, right.
Yeah.
up for you.
So I sat there and in the 90s, there was a Kohl's commercial where the lady was standing and looking at the doors and saying, open, open, open around Christmas. So I spent a couple hours doing that yesterday. And then miraculously, there was a window and I got on during the window. And I have kids stuff with an appointment down here today too. So we managed to get both things taken care of.
Thank you
My
for coming.
grandfather
today.
was born in Dollar Bay and I grew up in UP, so always glad to see a good Uper down here,
No better place to be in the world than on a keep on.
right? I should have had you pick up some pasties and bring them down. It's tough to get a good pasty down here, I tell you.
Good morning, Your Honors. Again, Monica Wilson, Assistant Attorney General on behalf of the people. I did have a chance to speak to Sister Counsel, and I checked yesterday. Mr. Cano has been paroled. So I believe the issues raised as to his minimum sentence are moot. And unless you had any questions, I think that should probably
Anything
be dispositive.
I have
else
nothing.
from the panel?
Thank you, judges.
All right, thank you, council. Safe travels back. Hopefully the snow starts to melt by June.
There are 350 inches in my house this year, Your Honor, so.
Wow.
Still pretty bad.
I know, it's insane. I was in Charlevoix last week and they still have like 1.5 feet up there. It's crazy. Moving on, that case will be submitted. Moving to docket number 4, case number 369760, People v. Wetter. Counsel for both appellant and appellee, please appear. Has anybody checked in for appellant or just appellee? Let's since you're up on number 5 as well, let's move on to number 5 and see if anybody shows up on number 4, if that's okay with you. Okay, thank you. We'll recall number 4 in a minute. Moving to docket number 5, case number 366024, People v. Justin Ray Mason. Counsel for appellant, please state your appearance for the record.
Good morning, Your Honors. Angeles Manassas from the State Appellate Defender Office on behalf of Justin Mason.
Okay, and counsel for the appellee? Thank you. Counsel for the appellant, you may proceed.
Thank you, Your Honor. We raised 2 issues in this case, which I'll briefly touch on both, unless this court has any questions on one particular issue or the other. I'll just dive right in.
I think we're familiar with the facts.
Okay.
This is the attorney that was intoxicated, right, and admitted the evidence of bestiality.
That's correct, Your Honor. And so we've raised 2 issues with respect to that. The first, that this was a violation of United States versus Chronic because counsel was intoxicated at the time that the jury submitted 2 questions to the court, and then those questions were answered. The answer was kind of discussed amongst the parties before the answer was given, and then the jury returned with a verdict after. The prosecution is claiming that we want a per se rule, saying that every time an attorney consumes alcohol during a trial, it constitutes structural error. That is not the case here. We are simply asking the court to adopt the test that many circuits have adopted in this country, which is that to determine based on the facts and kind of the totality of things, whether this is a critical stage of trial. Some circuits have held that In cases where it's simply just repeating prior instructions back, there's no need for the parties to kind of confer on what is given to the jury in response to their questions, that is not a critical stage. But here we have a different situation. We have two questions that were submitted by the jury, one relating to the facts of the case, and one relating to the jury asking what they would do if they couldn't reach an agreement on one or more counts and how they should proceed. And so both of those were not just simple reiteration of instructions that had already been given. The court sought input from the parties and then based on that provided an answer to the court. There were other avenues at their disposal. For example, with the second note, they could have issued a different type of deadlock instruction. They could have maybe admonished the court. There was nothing contained in that instruction about holding on to your honestly held reasonable beliefs. And if you can't come to an agreement, ultimately it is fair to deadlock.
Counsel, let me just understand, do we have to reach that issue if we were to conclude that counsel was ineffective for introducing the bestiality testimony into the trial?
No, you do not, Your Honor. If Your Honors find that counsel was ineffective for introducing that evidence from the complaining witness and that evidence prejudiced Mr. Mason at trial, which it did, we would ask that this court could grant a new trial on those grounds and Your Honors would not even need to reach the chronic issue. However, we would hold that we are entitled to relief on either front.
On either one. So either one, they're independent, and you win.
Yes, Your Honor.
Oh, talk to me about the prejudice.
The prejudice as to issue 1 or issue 2, Your Honor.
Issue 2.
Issue 2, this was particularly prejudicial for 2 reasons. One, Your Honor, this case was a credibility contest. There was no physical evidence. This was based on witness-to-witness testimony. And this was not only that, but this was testimony elicited by a trial attorney about his client in a child sexual conduct case involving animal bestiality.
I don't think that there's any issue that counsel's performance was deficient.
But what I'm speaking to,
I don't think the prosecution is even saying that. And that was the trial court's ruling, and I don't believe that ruling is clearly erroneous and it's unchallenged here. So the only thing at issue is the prejudice aspect. There was some corroboration, right, of what she said with the traffic stop, and then his admission that the money had been turned over. Is that enough here?
No, Your Honor. With respect to the money in particular, that was not, he did concede that was his, it's his niece. He gave her money. That was not contested.
And he gave her sister money.
Yes. And neither of those are really an issue. Relatives give their, niece, nephew, grandson, granddaughter money off all the time. That in itself is not an issue. What was at issue was the kind of the facts and circumstances surrounding that, which is where the parties disputed. Also, with respect to the traffic stop, ultimately, although the officer who made the traffic stop testified that Mr. Mason was kind of seen weaving, he was not ultimately arrested. He was let go with a warning. Mr. Mason does not contest that he was driving on that day and that he was pulled over. So those two things are not at issue. But as to prejudice and as to your question, Your Honor.
And the victim said that he was extremely intoxicated because he was slurring and stumbling and smelled of alcohol, none of which the officer noted during that traffic stop.
Your Honor, that's fair. However, being intoxicated, whether or not Mr. Mason was intoxicated and whether or not that's permissible or allowed, it has nothing to do with whether or not he committed sexual conduct against a child here. And so
I think you're missing my point. My point is that while there's some corroboration of her testimony being that he was stopped, there isn't corroboration on her description of him as being visibly intoxicated.
That's true, Your Honor. However, speaking directly to the prejudice behind issue 2 and behind this,
right.
This tipped the scales even further.
It's another sexual act and an extremely deviant sexual act.
That's correct, Your Honor. And so that is kind of what magnified the prejudice here and tipped the scales even further. It is true that we did have kind of competing accounts of the traffic stop and, what led to the events in this case or the alleged events in this case. Of course, it was a he said, she said, but that act definitely tipped the scales and prejudiced Mr. Mason.
So would the prejudice still be there had he fully developed that? My understanding was that somewhat his whole strategy was, well, I'll introduce this evidence and it's so ridiculous, the jury won't believe her and think that then her other allegations are ridiculous, right?
Yes.
Is it a different had he followed through on that strategy?
It's a kind of a double-edged sword, Your Honor, because it depends on what that follow-through had been. For example, here we have a case where this was introduced, there was extensive questioning, and as the trial court pointed out at the Ginther hearing, there was no follow-through in closing argument. There was no kind of fleshing out of this. So it really it doesn't seem that it was intended to be strategic when it wasn't used as, this alleged evidence that the complainant was making up fantastical stories, as he alleged the strategy was. However,
Is counsel allowed to make a determination during trial? They started down a path, said, you know what, in retrospect, in the middle of the trial, that wasn't a good thing to bring up, and change the strategy and not follow through? Is that not a strategic decision?
yes, Your Honor, counsel is allowed to do that in certain situations, but we have two problems with that here. One is that counsel was directly asked on the record, did your client consent to this strategy? Because the judge was so flummoxed that this was happening in the first place. And he said, yes, I checked. Basically, he checked with his client and that it was fine. That is not the case. Mr. Mason maintains he was never conferred. And that particular strategy is something that should be done in conference with one's client before proceeding. And so also this is not a matter of, I tried this style of cross-examination, it didn't work. In hindsight, I would have done it differently. This is an instance of introducing bestiality by one's client at a child sex trial. It is so egregious that there cannot possibly be a strategic reason for this.
Well, there might have been if he had actually
followed
followed through,
Thank you, Your Honor.
at least arguably.
Yeah.
Yes, you're right. And that would depend on what that following through looked like, and fleshing that out into a strategy. I could see a situation where conceivably, yes, but here, on these facts, no, Your Honor. Okay, thank you.
Thank you. Counsel Frappoli.
Good morning, Your Honor. It's Monica Wilson, Assistant Attorney General on behalf of the people. I will touch first on issue 2, which has to do with the bestiality. The trial court found there was no strategic reason, and we don't dispute that ruling. Clearly, that is not a clearly erroneous decision. So I think issue 2 turns on the prejudice prong.
Right.
So
It does.
there was corroboration, but also the additional corroboration was the testimony from the child's mother about her, I'll say, mental health or psychological symptoms that related back to around the time that she said this happened. So even though she said she recalls Mr. Mason being intoxicated, slurring at the time that he was pulled over, the officer did corroborate that, yes, they pulled him over. Yes, he recalled the victim being a DARE student. She recalls him being intoxicated. The officer, I think, was just based on his report. I don't know if he had any specific recollection
He
of the
did
stop.
not.
So maybe he didn't see it as intoxicated, but I don't think this case, it turns entirely on whether he was intoxicated at that stop or
No,
not.
but-
But I think the other evidence, so you have her corroboration, he admitted to giving her the money. Question is what the purpose for that was, I think was a credibility question for the jury to decide. And then you have the medical evidence that would corroborate the timeline of when she started having the psychological symptoms versus when she say the abuse
At the
started.
same time that somebody testified that her parents were getting a divorce and that she had daddy issues, right?
That is correct. And I think it could go either way.
Well, then.
But and again, it's credibility.
That's the problem.
Yes, and so, but I think that the jury could find her credible here. So even with the references to bestiality, I don't think there's a reasonable probability of a different outcome.
I didn't see in the record, there was reference to the report that she made to a school nurse
Yes,
about the abuse. I didn't see any record that nurse then did a report to police. Did I just miss that in the
I
record,
don't
or-
recall there being, obviously that person would be a mandatory reporter. I
Right.
don't recall any evidence one way or the other that was reported. So I think that is unfortunately a gap in the record there that we don't know if she did or not, but if she did report it, it wasn't then passed along appropriately.
Any further questions?
Did you have any questions on the first issue or just, I know we were focused a lot on the second issue.
Well, I mean, you agree if we rule on issue 2, we don't have to address issue 1 and
It depends how we
obviously.
rule on it.
I was gonna say, I would agree, I don't agree on the outcome, obviously. We think the conviction should stand. However, I agree that if you reverse on issue 2, then you don't have to address issue 1. But we would ask that you affirm on both issues as outlined in the brief.
Okay, all right,
Thank you, judges.
I appreciate it.
Counsel for appellant, do you have anything further? You have time for rebuttal?
No, Your Honor.
Okay, this case will be submitted. Going back to docket number 4, going to recall this item we called earlier. Case number 369-760, People v. Wetter. We have one attorney, Timothy Doman, for appellant, who's endorsed for oral argument. Has he checked in? Has not checked in. It is now almost 10:35 for a case call that started at 10. Counsel, why don't you state your appearance for the record?
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people.
All right, you are endorsed for oral argument. Is there anything you wish to add for the record other than what you stated in your briefs that you submitted?
No, Judge, I believe the brief covers it, so I would simply rely upon that brief unless Your Honors had any questions for me.
I have none.
Any questions?
I don't have any.
Okay,
Thank you, Judges.
thank you. That case will be submitted.
Um,
Did you wanna-
I'm just assuming Ms. Davis isn't back yet.
No, she is,
Okay.
she's still up.
Okay, so
Okay, so
you
you're on
get to
num-
argue your own cases. Great.
All right. Item number 6, case number 374-944, People v. Van Nett. Counsel, please approach. We have counsel for the appellant, and then on remote oral argument, Ms. Davis for the appellee. Mr. Dulon.
Doolan, thank you, Your
Doolan.
Honor. May it please the court, Steve Doolan here for Mr. Van Nett. I'd like to reserve 4 minutes for rebuttal if necessary. This case is actually pretty straightforward, I think. When I first read the transcript, the question that arose is still the most important question today, which is, what did Mr. Van Nett do for which he was convicted of this offense? And there is no answer anywhere in the transcript.
Really?
Really.
I watched I think we've all watched the videos.
Well-
So, I mean, essentially, you keep arguing that he interfered with his First Amendment rights. He never told him to stop filming. What he did was, he said, stop there. He's conducting a traffic stop. And he's taking him away from focusing on the traffic stop, prolonging the traffic stop. How is that?
Well, here's where the ineffective assistance of counsel also interplays, because if there had been a bill of particulars and there was clarity on exactly what behavior was prohibited, but if you allow,
had the video, right?
well,
You
of
had
course,
the
Your Honor.
exam. So
And my client's he's not a polite person. I wouldn't do what he did in terms of jumping out and filming a traffic stop on the side of the road by any means. However, what he was doing in
well, the
filming.
officer recognized he had a right to do it. He didn't tell him to stop filming.
Correct. And I agree absolutely, Your Honor. However, if we allow this to stand, it means that there's no clarity for citizen journalists in terms of when, where, and how they can film. So simply stating that there's this naked right to film without some understanding of where, when, and how. So the question is, was it the light on the camera phone? Was it the distance? Was it the time of day? Was it the proximity to the roads?
It was probably some of both.
I would
Yeah,
point out,
would
Your
you
Honor, had to
agree-
say probably.
Would you agree that state law says it's a felony for failure to comply with a lawful command, correct?
Correct.
And would you also agree that the police have a lawful duty to maintain peace and control the scene,
Certainly,
including traffic stops?
certainly.
Okay? And would you agree that it includes establishing a reasonable perimeter around their activities?
Absolutely, Your Honor. So-
Okay? And so in this case, the police on at least 2 or 3 occasions communicated what they believed was a reasonable perimeter and instructed your client to stay behind that perimeter. And 2 or 3 occasions, he ignored that order and continued to approach. I mean, we all saw the video, that's correct, right?
That is correct.
Okay.
So the commands that were given at different times as that interaction progressed were not consistent. They were not consistent with case law from other jurisdictions establishing fairly consistent buffer zones for filming of police activity. And this all could have been argued if there had been a bill of particulars and if it was very clear from the beginning what behavior, which command, which one of those distances is the one that was being ignored or violated? Was it all of them? But the prosecution never took the time to show that each one of those commands was lawful at trial. And that was certainly an element of what they had to prove.
Your client's objection was not to the perimeter and whether it was 2 feet or 8 feet or 15 feet or whatever it was. Your client's objection was, I can do whatever I want as long as it's not a physical act. That's what his objection was, not the size of the perimeter. Isn't that right?
Well, that doesn't, and that may be correct what was going on in his mind, but what's objectively true here is that as the process continued here from the arrest and the charge all the way through the conviction, no one can answer the question exactly which command was lawful and did the prosecution prove it was lawful at trial that he disregarded.
Why weren't all of them lawful?
They may have been, but that never got a chance to be argued one by one. Which one, what part of this, when you have a long conversation and you're saying that my client violated a lawful order, the prosecution has to show that that order was lawful. Now, because we've got interaction with a fundamental First Amendment right, the command may not have been lawful. The first command at 18 feet or 18 yards, whatever it was, may not have been lawful. And that was never able, there was no chance to argue that.
Want us to set a distance requirement that is fixed in the law, that in every traffic stop, this is how far you can come?
Some jurisdictions have, but I'm not asking for that today. All I'm asking today is a recognition that my client wasn't afforded his full due process.
Can the officers, would you agree that the facts and circumstances of each case depend on what is a reasonable perimeter?
Certainly.
This one occurred at night on the side of a highway. They hadn't been able to identify the 2 people who had just left the grain and grape. Right?
Can I answer?
Yeah, go ahead.
Okay, but the question is it the at night that's the issue here? Is it the distance? Is it the light on his camera? We don't know from this trial record, and the defendant never knew what exactly he was being convicted for.
But didn't he know that they told him 3 times at least, get back to where you were, get back to where you originally were, back up. Okay? And he refused all of those. So how does he not know what he's arrested for?
There's still an open question.
He warned him. He said, if you don't step back, if you take another step forward, you will be arrested. And then he took a step forward and he was arrested. How does he not know what he was arrested for?
Because there's still an open, unresolved question of whether each one of those was a lawful command. In other words, can an officer just ad hoc make it up each time and say, well, you're distracting me, so you need to just get in your car?
It goes to the facts and circumstances, doesn't it?
Sure, but there was no opportunity to properly defend here because there was no bill of particulars. And we don't know what the jury actually convicted my client of. It may have just been because he was a jerk and because it was nighttime, neither one of which would be sufficient grounds.
Except we presume that the jury followed its instructions and it determined that there was a lawful command given and that there was testimony during this trial that supported that a lawful command was given.
However, Your Honor, the prosecution certainly failed in its burden to prove that element that the command was lawful because we don't know what the command was. Was it all of them? Was it one of them?
I mean, we know what the commands were, don't we? I mean, he gave them.
We know what he said, but if you watch, I'm sure you have watched the video, Your Honor. I'm not challenging that.
Which one was an unlawful command?
Right.
No, I'm asking you.
That's not our burden, Your Honor. That's the prosecution's burden, which they failed to meet in this case.
All right.
So I would argue that the first time was maybe an unlawful command. But that's why some jurisdictions have reached a point where they created specific buffer zones. So they actually did have to draw a line.
One question just on moving off the First Amendment. Am I correct that the sister, the claim about the conflict and it should have been disclosed, the sister played no role in the trial other than something with service of process. Is that correct?
That's correct, Your Honor. And that's not our strongest argument, I absolutely admit, but we did feel it
Do you
should have
agree
been
to withdraw?
disclosed. I'm sorry?
Are you withdrawing it?
I'm not withdrawing it. However, your statement was
I think
correct.
it's the
Your
one
Honor.
you led with, so I
mean, she's in a much different position than the head of the family division in Oakland County in the Mayhew case. I mean, obviously that was a higher ranking role and we did not grant that type of relief even in that situation. So
I understand, Your Honor.
you're right. It's not your strongest argument.
would you agree that in some instances, speech can interfere with official duties?
It may be possible. I'd have to see what the facts are, what the speech is. If it's some kind of an incitement to riot on a roadside with a group of people, then,
Aren't there cases out there that say that?
so some cases say some speech is.
Okay.
Yes, Your Honor.
Okay.
But we don't know if that's what he was charged with here.
Okay. So your strongest argument, the way I understand it, is you're saying that there was no bill of particulars.
There's no bill of particulars, and there was a failure to prove that whichever command the prosecution was relying on in there was lawful. That's the prosecution's burden. If that's what he's being convicted of, is a failure to obey a lawful command, the defense doesn't have to prove it was unlawful. The prosecution has to prove it was lawful.
Okay. Anything else that you think we're missing? And you have time, you reserve time for rebuttal.
I did, Your Honor, and I think that I've made the argument here, so I'll stand by and wait. Unless there are other questions. Thank you.
Ms. Davis, please state your appearance on the record, and then you may proceed.
May it please the court, Jasmine Davis, Assistant Attorney General, appearing on behalf of the people of Michigan. This court should affirm Van Net's conviction and sentence for obstructing a police officer. Yes, Van Net is a self-proclaimed First Amendment auditor, but the reality is that he physically interfered with two Michigan State Police troopers' lawful traffic stop of a vehicle, which, as you said, it took place on a busy highway at night. We have Van Net, who pulled his truck in front of the stopped vehicle, exited his truck, quickly approached on foot with his cell phone camera in hand. And when he got to about 10 feet in front of the stopped vehicle, that's when the first lawful command was issued by Trooper Tardif, which was to essentially, don't come any closer. And he was repeatedly instructed to not come any closer, to step back. And yet Van Net came closer and closer. It was Van Net's failure to comply with those commands, his physical interference, his walking closer, his putting the camera flash on his cell phone so that the troopers couldn't really see him because, again, it was dark outside. And that's what got him arrested. The people are not going to contend he didn't have a right to film. He absolutely had a First Amendment right to film the traffic stop. And what's important, and that I noticed in opposing counsel's brief, as he says that Trooper Tardif's commands make it so that he'd not be able to film the traffic stop. That's not true at all. The command was simply to go back to where he was when he first came up on the traffic stop, and that was about 10 feet away. He was never told that he had to get back into his vehicle, that he had to stop filming. He was never told to go to a location where he couldn't film. So there just simply is no infringement on his First Amendment rights. I want to make a few key points. First, Trooper Tardif's commands to Van Net to stay back or to step away from the stopped vehicle were lawful. I just want to get into the case law briefly. This is from TikTok versus Garland, cited in the People's Brief. In general, restrictions may be placed on First Amendment rights, or laws may infringe on free speech so long as they, one, are reasonably and narrowly tailored to serve a substantial or important government interest unrelated to the suppression of free speech, and two, do not burden substantially more speech than necessary to further those interests. Put simply, content neutral laws such as MCL 75081D are subject to immediate scrutiny. Further, this court has recognized, and the United States Supreme Court has recognized that a police officer lawfully engaged in his or her duties has the authority to issue orders to maintain control over the scene. In People versus Campbell, cited in the People's Brief, this court has recognized that police officers face inherent dangers when conducting traffic stops, and thus they have a legitimate safety interest in maintaining control over the scene.
So
And
counsel, we
yes.
agree, I think from our question, you understand, we agree that officers have the right to do reasonable commands. What do you make about appellant's argument on the bill of particulars?
So as to the bill of particulars, there was video footage, there was a preliminary examination in this matter, and from the preliminary examination testimony, Vanette was adequately informed of the basis of the charges against him. In particular, Trooper Tardif, his body-worn camera footage was admitted, as well as testimony, which made it clear that Vanette was arrested for his physical interference with the traffic stop and not filming. And even as you pointed out, Your Honor, Trooper Tardif told him, "You take another step closer, I'm going to arrest you." It was clear in the moment to Vanette why he was arrested, and if it wasn't clear in the moment, then it was certainly clear from the preliminary examination hearing why he was arrested. From that evidence, Vanette could glean that his obstruction charge was based on the conduct that he committed before the arrest, which was the stepping closer and closer to the vehicle, and therefore a bill of particulars was unnecessary. In People versus Harbor, this court stated, where a preliminary examination adequately informs a defendant of the charge against him, the need for a bill of particulars is obviated. And so that would be my argument as to why there was no error in the there's no error in the trial court's denial for a request for a bill of particulars.
Any other points you feel are necessary for us to understand this case?
Yes, I would say going to the argument about MCL 75081D being overbroad or void for vagueness, I would encourage the court to rely on People versus Morris. That decision is published and it held that MCL 75081D is not overly broad on its face. Morris ought to be followed under the principles of stare decisis. The reasoning is sound. You can essentially interpret MCL 75081D narrowly to not cover conduct that is constitutionally permissible. It's clear from the statute that a physical interference with an officer's when an officer that's lawfully engaged in his duties is what's prohibited under the statute. And then as you apply it to Vanette, it's clear that he was arrested for physically interfering with the traffic stop and not filming. Again, he came close to the vehicle. He came within 8 feet of Trooper Tardif. He turned the flash on his cell phone. That is the conduct that got him arrested, not his protected speech under the First Amendment. And as to the vagueness challenge to MCL 75081D, a person of ordinary intelligence would understand what's prohibited by the statute. The reality is we're constrained by language. It's not possible to list out every single scenario. It's not possible to list out in a statute as in terms of obstruction, every single scenario that constitutes obstruction. It depends on the facts and circumstances of each case. And the law need not be written with mathematical certainty. I would kind of compare MCL 75081D to the third-degree child abuse statute that was discussed in People versus Lawhorn. And in that statute, MCL 750-136B-1E defined physical harm broadly as any injury to a child's physical condition. This court held that that's not unconstitutionally vague because an offense need not be defined with a mathematical certainty. So I would make the points that MCL 75081D is not unconstitutionally overbroad on its face or as applied to Van Nett, and it's not void for vagueness. You also touched on the fact about Paige Tardif. She was only involved in serving a motion and the motion responses and the felony information on defense counsel. That limited involvement where she had no decision-making authority in the prosecution of Van Nett, it doesn't raise a conflict of interest. That comes from People versus Mayhew, where the prosecutor employee has no involvement in the defendant's prosecution and no supervisory or policy-making authority. There's no conflict of interest. That familial relationship is insufficient to warrant disqualification of the prosecutor's office. So that's not an issue. And other than that, I would be happy to answer any questions. Let's see.
Any additional questions?
Nope.
Thank you, counsel. We appreciate your time here today and your argument. Mr. Doolin? Yeah, you reserve for, and you got a little bit of flexibility on that
Okay.
as well.
Thank you, Your Honor. I noticed that the light came up again just now, and the light came up earlier. And there was a light on the phone. And what we just heard is that what my client was convicted of involved the light, but at no point was there a lawful command to turn off the light. So this highlights exactly what I'm talking about.
I think there was a command to get the light, at least get the light out of my eyes or something like that, wasn't there?
But not to turn it off completely, right? So here's my point, though. And I understand that, again, my client's behavior was certainly rude, at least. However, what we're discussing now is the reasonableness of the officer's command, and that was not able to be fully discussed at trial, and the prosecution had the burden of proving that and never did. That's my point. I'll keep it really simple. My client was deprived of an opportunity to fully defend himself.
The jury followed its instructions, in my viewpoint.
I understand, Your Honor, and a jury instruction can't paper over a failure to prove an element. Okay.
So your claim is that, and here I'm reading your brief, the problem is you say that the denial of bill of particulars resulted in unfair surprise.
I agree. Yes, I believe that's true. And that is my strongest argument in the sense that the deprivation here was the ability to discuss whether the command was lawful. And if my client's position is, and I'm not taking a side in this argument, but this is the argument that was never had. My client's position is he couldn't film adequately from where he was. He's got a right to film. The officer's position was that that was too close, and that never came up.
So how is the distance? Police officers rely, and we decide cases all the time on dash cam video. And that dash cam video is further away than the officer instructed. There's tons of cases that are decided on those issues. How, when he's instructing them to back up 15, 20 feet from the front of the car, that's no different than a dash cam video, is it?
Well, here's what we're doing right now. We're arguing the lawfulness of the command.
But how
based
he
on
could,
what
you
we
would
saw.
agree, the officer never told him he had to stop filming.
I agree.
He could have continued to film.
Correct.
And he filmed as soon as he got out of the car, right? His truck?
I believe so.
If it wasn't effective from there, why did he start recording as soon as he got out of the truck? If that's ineffective, as you say, it's ineffective, why did he start recording before he got there? And why was he recording the whole time?
I'm not saying it was ineffective. My client wanted to get closer for his shot because he's got a right to film. That's why he was approaching. And I hear physical interference. He didn't physically interfere with anything. He was literally just standing there.
But it's not interference can take more forms, right? There's obstruction, there's interference. So as long as your position is, as long as he wasn't touching the officer, what if he wanted to get a better angle in the car? Could he get right behind the officer and film from that position?
So you're kind of making my point, Your Honor. Was he convicted of physical interference or was he convicted of disobeying a lawful command? Which one was it?
It was the lawful command. That was what he
Right.
was arrested for.
Right. But what I keep hearing in argument is physical interference. So maybe.
The
and that's
physical
what we heard at
interference
trial
comes up,
and in appeal.
counsel, physical interference comes up because that is A, what your client said was required for him to be arrested. And B, it comes up as part of your First Amendment challenge. I'd also know in your bill of particulars, the only way that argument comes in your brief is part of your cumulative errors that somehow it prejudiced. Is the bill of particulars, is your position that that is a standalone argument? Because that's not how it was argued in your brief.
I understand, Your Honor. And if I had the chance to do it over again, I might have highlighted that more, but we did include it.
Okay, but it was a sub part of cumulative error. Is that correct?
Exactly right, Your Honor.
Okay. Anything else?
No.
Nothing else. Thank you, counsel. We
Thank you.
appreciate your briefs and your time and indulgence in our questioning. As you can tell, we had a lot of thought and conversations about this case coming into today. And
That preparation is deeply appreciated.
and we we appreciate it. That case will be submitted. Moving on to item number 7. And we'll just wait a minute for Ms. Davis to leave us. No offense, Ms. Davis. Item number 7, case number 375156, People v. Nelson. Counsel for the appellant and the appellee, please state your appearances for the record.
Morning, Your Honor, for the record, Coleman Class B, W, 0, Your Honor, excuse me, no, here,
Thank you. Counsel?
Yes, Your Honor, thank you. I'm aware that the court is well versed in this case. I just want to highlight a few things in support of our request for a new trial based on ineffective assistance to counsel. We believe that the defense counsel's performance in this case was deficient, and we believe that deficient performance prejudiced the defense. In this case, not only were defenses available that could have been presented, I think it was clear throughout the case that there was not a defense presented at all. The first time that an actual defense was alluded to was in the closing arguments made by the defense counsel. And then as the record reflects, the court highlighted that not only didn't she believe that he had argued sufficient facts to support that defense, but that it wasn't requested in the jury instruction. The case law that we presented in our brief supports a few things. It supports that it could be the court can find ineffective assistance to counsel if there are defenses available that are not presented. In this case, we believe the facts did support citizens arrest defense.
But that's for if you're committing a felony. What evidence do you have that the teenagers were felons?
Well, the evidence that was presented at trial were Russell Nelson, the father of the appellant, called him and said, I hear voices around the range and I believe I see people on my property. That caused appellant to then go to the property to start investigating.
Right, but when he got there was nobody on the property. He encountered the people that he pulled a gun on and fired into the air off his property on a public street. So what facts and evidence were at trial that would support the giving of those instructions?
Well, number one, for I believe in a request for a citizen's arrest, you can either see the felony that was
which you would agree he did not do.
Conducted, or if you can prove that a felony was actually conducted, and in this case, that would have been a felony for breaking and entering, that you can make a citizen's arrest.
What at the time he pulled the gun on them and fired it into the air on a public roadway, what evidence did he possess in his personal knowledge that a felony was convicted by these individuals?
The evidence that was presented was that there were people on the property and that it was people possibly at the gun range. That was the evidence.
Could have been a neighbor walking the dog by, and that could have been the person. He could have done that too.
I'm sorry, Your Honor.
What evidence did he have at the time he pulled the gun and fired it in the air that it was these girls?
Well, I mean, number one, when he fired the gun into the air, he didn't know who it was, and he was trying to figure that information out right then and there. And that was the point that we were making, that he was trying to stop. I mean, he yelled for them to stop first.
I think that's a stretch to say that that gives somebody grounds for citizens arrest. I mean, this isn't the Wild West.
I understand, Your Honor, but I believe that at least that defense could have been presented along with the defense of property in the situation. I think the facts that there was testimony on the record that they had prior break-ins, that when
Was
they had
it,
called.
but you'd agree that it wasn't his property, right?
Well, the testimony is that they were either on his father's property and
Okay, so it wasn't his property.
in addition to that, that they were on that the father believed he heard voices over intercom at the gun range, which he was a part owner of that gun range. So that would actually be his property that he was defending. In addition, the facts show that his father is an elderly man, and his father testified that, hey, we're the only security that we have around here. And there have been cases where, and there was testimony that there were prior break-ins at the gun range, and that during those prior break-ins, when they did call the police, it took a while for the response time. So effectively, his father
So-
and the appellant do act as security for the area.
So your standard you're saying is that if somebody believes that the police aren't going to respond fast enough and there's a possibility of a crime, I can just take matters into my own hand?
No, what my argument is that the facts at least supported presenting some type of actual defense. So our argument is because no actual defense of any kind was presented, that amounts to ineffective assistance of counsel, and that's what the case law in our brief that we cited supports. In addition to no defense being presented, Your Honor, the last point we make is about a lesser included offense. And I believe the lesser included offense we cited to was brandishing a firearm. That's a misdemeanor. In this case, he was convicted of felonies. We believe that if the defense would have offered this lesser included offense of brandishing a firearm,
Would you agree that using deadly force is not permissible to defend land?
I would agree to that. And then
How is the
in the
firing of a
case,
gun near other individuals not deadly force?
well, in the case we cited that was comparable to that, which was People v. Woodhead, 1996, Mich. Ab. Lexus 476, the court did discuss when deadly force would be applicable. In that case, the defendant, I believe, fired 15 to 17 shots. He pursued the actual people that he believed were fleeing. However, in our case, there was one single shot that was fired in the air, 10 to 20 feet away from the people that he was pursuing. So I don't even believe that it was deadly force. I just believe it was a show of force in defending his property.
Okay. And just so we're clear on citizens arrest piece, your client, it wasn't in his presence. There was no trespass that occurred in his presence, correct? And would you agree that at the time he showed up, he had no evidence that there was any breaking or entering or anything stolen from the property?
The only evidence he had was the information from his father that it may have been people at the corral or it may have been people on the property.
Okay, and that's a trespass. That would have
Correct.
been a trespass.
Correct.
And under Michigan law, trespass is generally a misdemeanor.
Correct.
Okay, so that would not be a felony.
Correct.
So that would then remove it from citizens arrest.
Correct.
Okay, thank you.
And so in addition to that, our argument is that if the court is not going to find sufficient facts for a citizen's arrest, we do believe there were sufficient facts presented for defensive property that was never included in the jury instructions and not actually brought up into the closing arguments. And in addition to that, I believe it's People v. Yeager that or People v. I believe it was People v. Yeager where the court did say failing to include a lesser included offense could amount to ineffective assistance of counsel as well.
Would you agree that, let's say that the girls had went onto the property and damaged some property, there would be civil remedies available to the landowners?
There may be, yes. That
Okay.
is correct.
Any other?
Does defensive property allow for deadly force
Um,
under the law?
in some instances, I believe it does allow for deadly force, but I don't believe that question is presented here in this case because there was not deadly force used. There was no testimony that he ever even
There was a gun fired.
that's force. I don't believe that's deadly force. There was no testimony that the gun was ever pointed at them. The only testimony was that the gun was actually pointed and shot one time in the air, which distinguishes this case the People v. Woodhead. And I do want to. I didn't ask for this up front, but I would like to reserve some time.
Yeah, you have some time. I'll grant some time.
So on the brandishing, is that a necessarily lesser included offense?
I believe that the actions of the defendant of Mr. Nelson in this case did fall within the ambit of brandishing a firearm. So I believe that that could have been presented to the jury as a lesser included offense.
Well, that's not the question that I asked you. The question that I asked you is, are all the elements in brandishing within the charged offense?
I believe they are. I do have the elements of brandishing a firearm. I believe the only other element, I mean, shooting a gun in the air, I don't believe that's in brandishing a firearm, but in brandishing a firearm, you can even have be convicted of pointing a firearm at someone and it can still be found as brandishing. And in this case, the evidence shows that he pulled the gun, he fired it one shot in the air. So I believe it still would qualify as brandishing a firearm.
Okay. Any further? Thank you, counsel. You have time for rebuttal. Mr. Candela.
Good morning, Your Honors. May it please the court, Christopher Candela appearing on behalf of the Eaton County Prosecutor's Office. Your Honors understand this case. I can tell by your questions. You've reviewed my briefs. You understand my arguments. I'm going to rely on my brief. Their defense of property is not a valid defense in this case. You cannot use deadly force to defend property. There's case law that says felonious assault is not defense of property is not defense to felonious assault. He doesn't challenge or defense hasn't challenged the sufficiency of that evidence or the conviction in general. Citizen's arrest, there was no felony that occurred here. It's a trespass. Even a lawful police officer wouldn't be entitled to fire off a firearm into the air to prevent somebody from committing a trespass. And there's really no evidence of a trespass here either. The victims were in a public roadway walking away from the property. And as Your Honor had mentioned, this brandishing a firearm is a cognate lesser included offense. It's not a necessarily lesser included. It would have been improper for the trial court to instruct on that issue and actually would have created a reversible error had the trial court done so. Other than that, I'll answer any questions you guys have and I'll rest on my brief.
Should I make my comment? We're not you guys.
I'm sorry, Your Honor. You're 100% correct. It's the court and I apologize for that.
You know, it happens every month. So I just don't know what it is. People are just used to speaking more informally, but you know, we're still in court. But I appreciate your point and I appreciate you answering the questions that we raised with
Thank you. And I do apologize, Your Honor. Thank you.
Counsel, you have time for rebuttal.
Well, just briefly, I mean, albeit this isn't case law, but I'm not sure if the court is aware, but it was published in the Lansing Journal that the entire Eaton County Public Defender's Office was dismantled. That was something that happened during the course of this appeal. The person who led, or the attorney that led the Eaton County Public Defender's Office was the attorney who conducted this trial. I just believe it's clear from the record in this trial that there was no defense that was proffered in the first place. I believe there could have been some more facts presented that would have supported a defense of property, so that it could have been included in the jury instructions and the jury would have had something to consider. I believe that what was presented in front of the jury did not present a defense at all, and because of that he was not afforded the constitutional right to effective counsel.
Sometimes there is no defense, right? No legally recognized defense. So I understand your point. I just happen to disagree with you that I don't think on these facts that the defenses that you're saying counsel was ineffective for raising are supportable, either legally or factually. So
Any further questions, Judge?
Nope. Thank you.
Any last points you wish to make?
No, Your Honor, thank you.
All right, thank you. That case will be submitted. Thank you for your thoughtful briefs and responding to the arguments. I know we're kind of hot bench on you on these issues.
Absolutely.
All right,
Thank you.
thank you. Nice job. That case is submitted. Moving on to item number 8 on the docket, case number 375-636, Anthony Banasek v. State of Michigan. Counsel, you may approach and state your appearances on the record.
Good morning. Philip Ellison appearing on behalf of the appellant this morning.
Good morning, Your Honors. Assistant Attorney General Ryan, we're appearing on behalf of the state.
Thank you, counsel.
Before we begin, I was one of the you guys at one point, I think about 3 months ago, and I caught myself in the moment I said it too, but good morning, Philip Ellison.
I know our court officers now give the speech where they say, oh, especially if Judge Letica's there, please.
We're so nervous being here, right? That like, this is my first time. Anyway.
No.
Good morning, Philip Ellison, on behalf of the appellant this morning. The issue I'd like to address first is the takings claim first itself. And to be clear, the claims against the state are pled as counts 3 and 4 of the verified complaint, which is a inverse condemnation action and a state constitutional claim. And that's really important because the Michigan Supreme Court has explained in Raffaelli that our state constitution is stronger and more protective than the federal counterpart. That's what I think is missed by brother counsel's arguments in his response when reviewing for the preparation for today. Because the standard is stronger, that means there has to be a different standard that applies under the Michigan Constitution rather than the Fifth Amendment under the Fifth Amendment standard. So where is that standard? The Michigan Supreme Court has supplied it to us. It gave it to us originally back in 1889 with Vanderlip. It was reaffirmed in Tome, and it was most recently reaffirmed in Peterman. Any injury to the property of an individual which deprives the owner of the ordinary use of the property or results in partial destruction or diminution of value is a taking. Our standard is destruction or diminution, not the Fifth Amendment standard, which is lesser. And this court doesn't have to answer what the Fifth Amendment standard is because we're under the state constitutional taking standard, and we have that standard that's been met here. So I would ask this court, as a matter, and as I've noted, and I think brother counsel will agree with me, this is a first impression issue for this court, for this state actually. And we would ask the court to determine that in circumstances where there was more than de minimis property damage, and in this case, looking through the record, there is far more than de minimis damage. A tank was used that battered into the house, countless rounds of pepper spray and very noxious chemicals, whose names I'm not even going to try to pronounce, destroyed windows, destroyed walls, destroyed drywall, had to be completely gutted. And in fact, when it was all said and done, the state police just left that mess and that destruction for the property owner.
Am I right in the facts that the process and the appearance of the police was done at your client's request initially?
No, that's an important point. There's an error that my brother counsel keeps repeating. It is not true. My client had a legal obligation to serve an eviction notice through the courts. And he did that by having a court officer, Patrick MacGyver, who was not there as the agent of him. He's an agent of the court, effectuating the court's eviction process. Mr. MacGyver was the one who summoned the Bay City Police. The Bay City Police then summoned the state police. My client did not summon the state police to the scene, ever.
Wasn't he part of giving them access to certain parts of the building and giving instructions how to approach the building?
He gave the Bay City Public Safety access to the building. He did not give the state police, and he did not give consent to the state police to enter the building or to conduct any damage to the property itself.
But at some point, didn't it turn into a safety issue and a public safety concern? You had an individual barricaded in and threatening with gun or with knives or?
Well, what I would argue, what I think this started as when Bay City Public Safety was originally.
Answer my first question, then you can give your explanation.
Well, I can't answer it directly with this because first point is when Mr. MacGyver was brought in and then the state or the city police were called, I think up to that point right there, it was an eviction process. When the state police then entered, or excuse me, when the Bay City Police then entered and found out that Mr. Nielsen had felony warrants, it converted from being an eviction process to being a fugitive apprehension process. At that point, then, that became a public purpose. When they then go into access to answer you now, this is the point I can answer your question now is at that point, they were in fugitive apprehension mode, public process, purpose process at that point when they perceived Mr. Nelson as having a gun, which in fact he never did. And I know Brother Counsel notes in his thing, he talks about the knife. It ended up being a putty knife. It was not an actual knife in and of itself. Now, I get at the time, it was not all knowing in that respect. And I don't argue that police can take a protective stance. We heard this morning the arguments about being on the roadside in inherently dangerous situations. But that doesn't give the police the opportunity and the authority to destroy a home for the purpose of public apprehension without the payment of just compensation.
Weren't there reasons that your client wanted to evict the tenant? That it was the apartment was, it was almost a hoarding type situation and.
Oh, he absolutely wanted him evicted. He didn't want his house destroyed though to do it. And that there was.
I understand that, but prior to that morning, when all this started, what was the condition of the property?
The condition of, well, I want to be clear, the condition of the property was a normal house. I think your question is what was the condition of the apartment that this was in? It was a hoarding situation. There's no question about that. It was a situation where Mr. Nielsen had a bunch of junk in there. But the reality is that having a bunch of junk is not grounds for destruction of the property
Right, but
itself.
isn't there a part of, like, they were able to remove a drywall? It doesn't sound to me like it's a ordinary house as people would understand it. Like, you can't just go to a normal house and say, oh, let's go in through this closet, remove a piece of drywall, and we can see into the room where the guy is, which is what happened here. That's not, as you put it, it was a normal house. That's not a normal house.
The unique circumstances here is that, I'm trying to remember the apartment numbers. I believe Mr. Nielsen was apartment number 3. Apartment number 2, which has a shared wall with apartment number 3, was in the midst of renovation. That's why if you actually watch the video itself, when the Bay City Police were there, that's why they were able to cut a piece of drywall out of the back closet, was because they were in the midst of renovation. So it wasn't like this was the way the house always was. It was in mid-renovation, apartment number 2. And please forgive me, I don't know if it's 2 or 1, but it was the neighboring apartment was being in the midst of renovation. And that's why there was easy access. And my client agreed to cut that one piece of drywall for the Bay City Police. There was no agreement or consent. And this is one of the errors that Judge Redford did below, is saying my client consented to the destruction of all this property. He consented to the one piece of drywall being cut out in the very beginning that you have all the video of that's in the record here. Once the city police called the state police, and the state police didn't operate through that one wall, they went from the outside, hitting it with a Bearcat, hitting it with pepper spray, hitting it with all of these weaponry that actually poisoned and then destroyed the property itself. And of course, this chemical that gets blasted with these large caliber guns that shoot through, this isn't like it just dissipates on its own. It's still even there today. And still, if you touch this today, it reactivates that process, and actually it's poisoned the apartments where it's been shot into and has caused that destruction. My client cannot afford to pay for the repairs on this because of the level of destruction the state police did. What I would argue to this, and going back to the top of this argument here, is that because Michigan has that heightened standard under Vanderlip and Tome and Peterman, that puts this case into Wagner and Steele territory that we've outlined from both Texas and Minnesota. We think those are the applicable cases, and particularly Wagner is.
What Minnesota and Texas, how are their constitutions?
The Minnesota Constitution is similar with the takings claim as ours is. It's not word for word the same, but it's the same takings protection as it's been interpreted. It's been interpreted as more protective, just like ours is, than the federal Constitution. Texas, on the other hand, has a provision for takings or damage, which may be the basis for distinguishment, but that's not been, at least the way the Texas federal judge, which Baker's got a unique posture, and I don't want to spend a ton of time on it, but the Baker was originally ruled on a Fifth Amendment takings ground. The Fifth Circuit reversed. went back to the trial judge said, okay, well, I'm going to find it as a taking under the Texas Constitution. And he granted that and found that it was a violation of the Texas Constitution. Because again, Texas, like other states, have more protection than the federal counterpart. Now, I acknowledge there are some states, for example, California does not have a greater protections under their taking clause than the federal counterpart, which might explain why California is not found the same way. But for those states where the protection is greater, that has been found that when you do this level of damage, more than just de minimis, more than incidental damage to a piece of property, it's not that the police can't do the damage that's necessary. It's that you have to compensate for the remediation and fixing of it after the fact.
But weren't their actions actually directed at apprehending the individual inside the apartment as opposed to, I mean, they were responding to a situation to apprehend the individual inside.
I agree. That's what makes it a public purpose. And when you have a public purpose, if you're destroying property in the advancement of public purpose under Vanderlip, that's a taking. I would encourage this court, you're not being asked as a matter of policy whether this is good policy or not. What you're being asked under Vanderlip, Tome, and Peterman is to apply this circumstances to that constitutional yardstick. And the constitutional yardstick is any injury, not any injury except police. Any injury where the property of the individual is deprived or results in partial or complete diminution of value. This fits that yardstick perfectly. And unfortunately, I guess my brother, what my opponent would have this court do is act as a policymaker and rewrite the Constitution to build in a police exception where none exists here on its face. So I would ask this court to determine, would be in short, and I'd like to adjust the jury question in just a moment, but the issue here today is I would encourage this court, I think the best case law to support, and I would ask this court to follow, is the Wagner decision from Minnesota. We think it's factually the same, and legally it's on the same.
All right.
As to the jury issue itself, I would point this court, I wanted to just highlight one point to this court on that issue. The controlling case law in this is Reiser and Biggie. And both of those are Michigan Supreme Court cases. And I think Reiser is particularly apropos here, is to say any act which destroys or materially impairs the right of trial by jury, according to, in the course of the common law, in cases proper for cognizance of a jury, is unconstitutional. So in short, if a statute takes away the right to a jury trial, not the mode and how to activate that trial, but if you take away the right to a jury trial, it's unconstitutional. Now, the pushback is Hill. Hill didn't really analyze things very well, but it came back and said, well, we have a condemnation case, and a condemnation case never provides for a right for a jury. For that case, they're right. But this is not two things. One is this is not a condemnation case. And number two, under the 1908 Constitution, there was an exception for the state to provide a jury for direct condemnation cases. It's Article 13, Section 2. I would implore you to look at that because that created an exception until the 1963 Constitution came into effect that took that exception away. As such, Hill is no longer relevant law. Reiser and Biggie are the controlling law. And because that exception that the state enjoyed under Hill is no longer there, the right to a jury trial shall remain. And as such, the Court of Claims Act cannot take that right away because under Reiser, that, as the Supreme Court has said, would make that unconstitutional. I encourage the court. I think we've laid out, a pretty compelling arguments as to some pretty heady issues that need to be addressed. I'm happy to answer any other questions that the court may have. But other than that, we thank you for your time this morning.
All right. You have a few minutes left for rebuttal.
Thank you.
May it please the court, Assistant Attorney General Ryan Weir appearing on behalf of the state. Your Honors, this case presents two distinct issues. First, this case asks this court to convert a dangerous, rapidly evolving public safety emergency into a constitutional takings claim, and Michigan law does not allow for that. The Court of Claims got it right for two reasons, and this court should affirm. First, there is no constitutional right to a jury trial here. Plaintiff does not have a right to a jury trial because claims against the state exist only by legislative consent, and the legislature has placed those claims exclusively in the Court of Claims. Michigan courts have long recognized that Article 1, Section 14 does not override that structure. A takings claim against the state is not a common law action. It is a statutory pathway, and it comes from conditions the legislature attached, including a bench trial. Second, and more fundamentally, this was not a taking. Plaintiff asked this court to analyze routine law enforcement conduct under the takings clause by labeling it a public use, but that framing is misplaced. Police work, arrests, searches, tactical responses have never been recognized as a public use under the takings clause. It may serve the public, but that is not the constitutional test. If it were, virtually all government action would become a compensatable injury under the takings claim. The proper framework is the Fourth Amendment's reasonableness standard, which is specifically designed to evaluate the legality of police conduct, including the manner and the scope of force used in executing arrests and securing property. That distinction matters because once this case is placed in its proper constitutional lane, the question is not whether compensation is owed, it is whether the officer's individual actions were reasonable under the circumstances. Plaintiff tries to recast this as a public use case, but that framing fails for two independent reasons. There was no appropriation. The state never took the property in the literal sense. And there was no permanence. So the state did not, the one case that he relies upon is the DNR case where they installed jetties on the beach and it ate away at someone's property. There was nothing like that in this case. This was a unfortunate circumstance that I think we can all agree devolved into a dangerous, fast-pacing moment. But the police were completely reasonable with their conduct. And this does not fit in the traditional, takings claim. If plaintiff is right, every police response, every barricaded suspect, every hostage situation becomes a potential takings claim. This is not the law, and it would fundamentally alter how takings jurisprudence exists in this state. For these reasons, the Court of Claims correctly granted summary disposition, and we would ask this court to affirm. And I would welcome any questions if the court has any. Any questions? And then before I leave, Your Honors, I would also join Brother Counsel's request in this being a published decision. The case law is fragmented on this issue. This is kind of a reoccurring issue both at the state and federal level. And I would implore this court to look at Slayball, which was the most recent Sixth Circuit case we cited in our brief. Slayball, I think, is very on point with the facts in this case. And I also want to clarify one thing that Brother Counsel has said on the record that I take issue with. At both the plaintiff's deposition, I asked the plaintiff under oath, were you the one that called 911? And he said yes. That's in the defendant's appendix. I also asked the foreman who worked for the plaintiff, did your boss call 911? And the foreman said yes. So when I made that factual representation into the court on that, I was relying on the deposition transcripts that the court has. Importantly, I think where the statement comes back where plaintiff is now claiming he did not call 911 is a affidavit that was executed after the Court of Claims issued its initial ruling on our motion for summary disposition. Obviously, I had no knowledge of that at the time I made the representation to the court, so I just want to clarify that for the record.
I think the representation today was that he didn't call the state police.
Correct. Yeah, correct. I think there's a further representation built into that, though, that he didn't call Bay City Police Department. The court officer did. Obviously, after Bay City Police retreated from the property, they're the ones that called in the ES team from MSP because they could no longer handle the situation. Thank you, Your Honors.
Counsel, you have a few minutes for rebuttal.
Judge Boonstra, you were correct. I was pulling up the affidavit. We did not, as the affidavit lays out, we did not call the state police. The purpose of the call was for Mr. MacGyver, who was there as an officer of the court. He was there as an agent of the court in those circumstances. Once the city police called in the state police acted way in excess of any possible consent, any possible authority they had to be there. Now,
So does that get to the point you just made then, does that get to Applebee's point that the correct standard of review is the reasonableness under the Fourth Amendment?
This is a state takings claim. This is not a Fourth Amendment claim. They're trying to put a better, easier standard because you did not hear from brother counsel trying to refute the applicable standard that the Michigan Supreme Court applies to state takings tests. It's Vanderlip, the any injury standard in Vanderlip. You're bound by Vanderlip, Tome, and Peterman for state takings claims. We have not made a Fourth Amendment or the Michigan constitutional equivalent of a Fourth Amendment claim. That's the problem that exists. He wants the standard that's better for him from a different part of the Constitution that doesn't apply here.
Do we just look at how you label it versus the true nature of the claim?
Well, then
I'm pretty sure that our precedent says that. We don't just, we're not bound by the labels that attorneys may put on a claim because for the very reasons you stated, that lawyers are smart and crafty people and choose the
crafty.
to
That's a
frame
good.
the
That's a good
questions.
word for it. Crafty people. Respectfully, I'm representing this court. I did not make and purposely did not make a Fourth Amendment or Fourth Amendment equivalent. You cannot graft Fourth Amendment jurisprudence onto a Fifth Amendment claim. I have made a state takings claim. Now, if that claim fails, you just simply conclude I failed as a matter of law. But the important part here is the standard. Again, I'm looking to a particular, this Michigan Supreme Court has supplied this court with the applicable standard. It's Vanderlip, the injury standard, and that's the one I'm proceeding under. If this court finds it doesn't apply in those circumstances, then so rule. But don't graft a Fourth Amendment standard into a state takings claim that's otherwise here. I would also finally just point to the court to that the purpose of the state police when they arrived and caused the damage that they did. This is not a run-of-the-mill Mayberry, Andy Griffiths and Barney showing up to take care of a 70-year-old man who's hard of hearing, who's got a health problem and a mental health problem. What they did was they destroyed this home. And what's unique about the state takings claim is not that they can't destroy the home. They can do it.
You say the home, but earlier, how many apartments were there in the home?
I believe there are 6.
So 6.
6.
And how many were under renovation at the time besides the one that was occupied?
1. Or how many were occupied?
Yeah.
All of them were occupied except the one. Well, no, I take that back. The basement one was in the midst of almost being done renovated, and the apartment number 2. So
2 of them were being
2 of them, and then the remaining balance of the 6 were fully occupied. Yes.
Okay.
Yes. And when I use the word home, I use home interchangeably with property. Really, the standard under Vanderlip is property. Any injury to property in a house. 4 walls, a roof, is property. We're not claiming any sort of heightened obligation because this is a home. It's any damage, any injury to property, which is the standard under Vanderlip. I would last point out to the court that when the state police got there, if you listen to the bullhorn, the video I think is pretty insightful in this, and then you listen to the bullhorn is the guy in the Bearcat says to, Mr. Nelson, come out, he's not saying you're here, you need to vacate the property because you're being evicted. They said, you're here, you're under arrest. He was being arrested for the fugitive apprehension based on pending warrants that exist. Brother counsel pointed to MCL 28.6 sub 5, which creates the public duty, which means there's a public purpose in apprehending fugitives. What they were doing was a public good. It was a public purpose to apprehend. They were not there. The state police were not there to fulfill the eviction. They were there to effectuate the arrest. And I think that's an important distinction.
I agree with that, but help me understand then why is this not just a pure Fourth Amendment issue then?
Because our claim is that they caused damage to the property itself. It isn't that it's not an unlawful, we're not claiming an unlawful seizure of the person.
So anytime there's incidental damage to the property through a police action, you can have a condemnation claim.
What I'm arguing is, I don't know exactly today, I'm not prepared to give this court where exactly the line is between incidental versus substantive damage that exist. But I think that this example of this case is so far on the far side of the spectrum. This is a Wagner style case. And I'm imploring this court, Wagner is the court case this court should use.
I thought it was Vanderlip.
I'm sorry. Oh, well, Wagner is how to apply. Fair enough. The standard comes from in our court for what this court has to apply comes from Vanderlip. But the way to apply those situations is the Wagner case, which is the same in that respect. But the point I guess I'm getting at here is what Brother Counsel has asked this court to do is now to apply a Fourth Amendment standard. And then at the very end, he says, look at Slayball. Slayball was a Fifth Amendment claim. Our Constitution, as the Raffaelli Supreme Court said, our takings claim is more protective and stronger than the Fifth Amendment counterpart. So Slayball has no applicability.
Okay. I think
So
we
other than
understand.
that, unless the court has any further questions,
I just have to add, I give you credit, Mr. Ellison. You seem to have a knack for finding cutting edge first impression issues, and here we are again. So it's always a pleasure.
well, I'm hoping one of these times I can convince you to come to the dark side. So I'll say this as a final note, just as a personal I know I always have a strong, hard time on this end of the bench, but I'm hoping this end of the bench will see the light here today. So, but it's always a pleasure being before you. Thank you.
I appreciate the argument and well briefed and certainly cutting edge, as you said. So with that concludes our, that case will be submitted. That concludes our 10 a.m. Call. We're going to take a brief 5-minute recess before we move on to the 11 o'clock call.
Court feels the same admission is now in session. Be considered.
Thank you all for your patience. We'll resume our case call today and start the 11 o'clock call. The same instructions that we made earlier regarding, focusing your argument still apply, as well as being conscious of juveniles and sex victims and other private matters. So with that, let's call item number 9, case number 369-217, Hopala v. Penagor. Counsel?
Good morning for 5 more minutes, Your Honors.
Yep, there you go.
Jordan Ayler-Smith on behalf of the appellant mother in this case. Your Honors, appellant mother asked this court to reverse the trial court's July 2023 order and to remand for further proceedings. As Your Honors will have seen from our briefing, the issue in this case is the trial court's lack of compliance with the requirements of the Child Custody Act before entering an order that essentially doubled appellee father's parenting time with the children. The trial court made no findings as to proper cause or change of circumstances, made no findings as to the established custodial environment, and made no findings as to the MCL 722.23 best interest factors. I think the error is rather straightforward, and I don't have really anything more to add for Your Honors. I did have a couple of updates just in terms of some of the issues that I raised.
Before you do that,
yes, Your
didn't
Honor.
the July order that you're appealing simply enforce an earlier April order?
So
you did not appeal. So how does that affect what we do?
So you are correct, Your Honor. That is the phrasing the trial court used, I believe, was that the order was giving effect to the April parenting time schedule. I think the problem is that the statute says that the trial court shall not enter in order to modify a child's established custodial environment. And the father wasn't exercising the April schedule. The April schedule, I believe, did what this order did, which was afford him parenting time every weekend, but he had only been exercising every other weekend.
The April order still was what the April order was, whether anybody followed it or not, right? I mean, if you objected to the order, shouldn't you have appealed that one?
You're correct, Your Honor, that it doesn't really matter what the order says, because when we're talking about a child's established custodial environment, and the trial court in this case did enter an order was entered, and the trial court never took a look at whether or not that order was actually modifying what the reality was for the children. And there's case law from this court that says, an established custodial environment can be established without a court order, in violation of a court order, if there is a court order. So the problem with what the trial court did in entering this July order and then having father start exercising this schedule is that the trial court never stopped and took a look at what does this mean for the children, rather than yes, we have these words on paper, but when we're talking about a child, which in this case, we're talking about two children, we have to stop and take a look at what does this order actually do to the reality for the children? And that's what the law requires the trial court to do before entering an order. And I think in this case, it's especially egregious when we're talking about the fact that father had had very, very limited parenting time with these children for an extended period of time, and then all of a sudden starts exercising every weekend with them. So that's our position, Your Honor, on that particular issue.
Would it have been an issue for the father if he just went and said, I want to go back to the April order, which was still more than what this established custodial environment was at that time of the July order?
So I just want to understand your question, Your Honor. If father had gone in with his, I think it was a May motion and said, I just want to exercise what I'm supposed to have under the April order.
Correct.
I mean, I think it's the same error here. I think the problem is that father was voluntarily not exercising the April schedule. So if he were to come to court and say, let's say, hypothetically, I'm being prevented from being able to exercise the April parenting time schedule, the trial court still has to look at what order, if I enter this order, is it going to change anything for the children? That's the important part. And that's what the law requires here. So even if father had come to court and said, for whatever reason, I can't exercise the April parenting time schedule, trial court, you need to enter an order enforcing it. That order still needs to assess whether or not it's going to affect the children's established custodial environment.
Does the statute say that every time you have to go through that?
I'm trying to remember the exact wording of the statute, Your Honor, and forgive me, I may be off on a word or two, but I believe the statute says a trial court may not enter an order modifying a child's established custodial environment unless there's clear and convincing evidence that the change is in the child's best interest. And again, I don't know the exact language of the statute offhand, Your Honor, but I believe that is what it says.
What's your update?
We raised a couple of issues with appellee father's stepson in our brief in a couple of places. I learned yesterday that stepson had passed away. And there was a new trial court judge that was assigned to this case down below. The prior trial court judge retired, and there is a new trial court judge. Father did file a motion for more parenting time in June of 2025. Found that out last week. That was great. The parties have attended, they had one mediation session that wasn't successful. The new trial court judge has kind of put proceedings on that motion on hold until Your Honors resolve this case. So unless Your Honors have any further questions for me, I would just ask that this case be submitted.
All right, that case will be submitted. Thank you for your time.
Thank you.
Moving to item number 10, case number 377332, Anders v. Sargent. Counsel, please come forward and present your appearances for the record.
Jordan Ayler Smith on behalf of the appellant father.
Good afternoon. Oh, no, I'm in early at this point. Your Honors, Jeffrey Wagner appearing on behalf of the appellee mother in this case.
Thank you. You may proceed.
Appellant father asked this court to reverse the trial court's order denying his motion for change of domicile. I don't really have anything for Your Honors outside of what has been presented in my briefs. We are limited essentially to factual arguments in this case because the trial court did follow the proper procedure in terms of how to correctly address a motion for change of domicile. I really don't have anything outside of what is presented in my briefs.
Do you have a question?
No.
Okay, I was just going to ask and make sure my understanding is correct. I saw a lot of argument and sort of speculation of the parties of, hey, this is why Georgia would be better schools, less crime, et cetera, et cetera. I didn't see a lot of, statistics or evidence or affidavits or any of that stuff.
Meat on the bones.
Yeah. Is there anything, is there something you can point us to that is different than sort of what my understanding is?
I don't think your understanding is necessarily incorrect, Your Honor. This was a very thin record, especially in terms of a change of domicile analysis. What I will say is that a change of domicile analysis always has some element of speculation to it, right? MCL 72.314A has us, considering whether the move has the capacity to improve the life of the relocating parent and the child. There's always a necessary element of speculation involved there. But, I'm not going to try to argue facts that aren't there, because there are just some facts that are not there. Our position is that there was enough to get to the next step in the analysis, which would have been the assessment of the child's established custodial environment, and then the MCL 722.23 best interest factors. But like I said, I'm not going to try to argue facts that aren't there, Your Honor.
Thank you.
I'm assuming they moved, right?
As far as I know, they did not move. I have no confirmation of this, but I have some emails from my client's wife where it looks like she probably started her new job. It might be remotely. I'm not positive on that, Your Honor.
All right.
Thank you.
Thank you.
You still have time for rebuttal should you need it.
Thank you.
Your Honors, in your remarks to Sister Counsel, who I've dealt with on a number of cases in the past, and they do a remarkable job. I'm not unsympathetic to the cards they were dealt on this case, having been on both sides of domicile cases on a number of occasions over the last 20 years. And the reality is that under the applicable case law, most notably the Yachik case that we rely on primarily in our brief, in order to make that threshold showing, you have to develop a detailed comparison of and contrast between domicile one on one hand, domicile two on the other. And at the trial court level, in order to meet that burden, trial counsel has to prepare and put forward meaningful evidence of, say, crime statistics in Grand Blanc versus Savannah. Never happened. School rankings, graduation rates in Grand Blanc versus the Savannah area. Again, never happened. The trial court was, I think, very astute in pointing out those evidentiary failures in its very detailed and thoughtful opinion. And given the insufficient proofs that were produced at the trial court level, I think this is, on one hand, domicile cases are by definition very difficult. We're dealing with a disagreement over what to do with the 6-year-old girl and where she should live. That's going to be a difficult call, really, by any metric. But if we take a step back, I think this is fundamentally really a civil procedure case. And it's about what happens when the moving party fails to meet his or her burden from an evidentiary standpoint in asking the court for some form of relief. And in this instance, a very significant relief in moving a young child who is thriving by all accounts in the Grand Blanc community schools, involved in a myriad of extracurricular activities like soccer, dance, and perhaps most importantly, is now extremely bonded with an infant sister for whom she has immense love. And if we look at the context that this case arises in and the level of evidence that was presented at the trial court level, there is simply no reversible error that appears anywhere in the lower court record. I brought up the Yachik case in my brief and also during my opening remarks. It's rare in these family law cases, because they tend to be very fact specific, that we encounter a published decision from this court that's truly on all fours. But I think this is one of those cases. Facts in that case, we had a chance to enroll a child in private school. I think it was a Catholic school in Pennsylvania. And the same problem was presented there. There was no meaningful comparison and contrast made between the Alpena public schools on one hand and this Catholic school in Philadelphia on the other. And without the crime rates, without calling the administrator from the school to, and I've done this before in Oakland County cases where you'll subpoena the superintendent or the principal, and they'll give you the song and dance about why this district is superior than the other. We simply don't have that here, Your Honors. I'm happy to answer any other questions the court might have. Otherwise, I'll rely on my remarks today, the Yachik case, as well as the other arguments set forth in our brief.
Thank you, counsel. Nothing further. Thank you. You have time for rebuttal?
Just very briefly, Your Honors. As Brother Counsel kind of illustrated, the Yachik case, in my view, had fewer and more targeted facts than our case does. I think our case has kind of more global facts rather than in Yachik, where it was very, very focused on just the child's schooling. Again, our position is that we did meet the evidentiary burden to at least get to the next step of the analysis, and I would encourage this court to reverse. Thank you.
Thank you, counsel. That case will be submitted. Calling item number 11, case number 370044, Zaki Anesthesia versus State Farm Mutual Automobile Insurance. Counsel, please approach and state your appearances for the record.
Good afternoon, Your Honors. Matthew Payne appearing on behalf of the plaintiff appellant. I have
Yeah, if you can just give us a moment, counsel, while everybody gets situated.
of course.
All right. All right, appellant, Mr. Payne, you may proceed.
Thank you, Your Honor. I do just have 3 points to make this afternoon. First, I want to note that the trial court ruling in this matter was premised on MCL 500.3112, which delineates how PIP insurers discharge liability for benefits, and it contains numerous elements, one of them expressly being payment. In this case, there was no payment, let alone were the other elements met. On appeal, State Farm contends that there was quote unquote payment, relying on a dictionary definition of that word, incorporating consideration aside from money. However, in the context of this statute, it does go on to say that liability is discharged only to the extent of, quote, the payments, which clearly refers back to the initial payment element and evincing an intent that the legislature did mean money in this context, not some other consideration. If liability is discharged only to the extent of the payments, as the statute plainly says, then payment of something other than money would render that phrase entirely nugatory. Second,
Yeah, sorry to interrupt. Can you clarify for my understanding the timing of the services provided in the requests for payment by your client as it compares to the jury determination and the ultimate settlement?
Sure. My client is an anesthesiologist who was providing services to this injured person while her litigation was pending.
Okay.
Those charges were denied. I filed litigation to recoup the unpaid claims. While my litigation was pending, the injured person's litigation concluded, and then she signed the release, or more generally, the contract purportedly waiving any additional claims from State Farm. So there was treatment before that happened, and there was treatment after that happened. And in the trial court, Judge Connors said, well, State Farm had notice before the release of those dates, those are still in. This was a partial dismissal as to the charges incurred after Ms. Jackson executed that contract.
Okay. So it's the charges after the release that are at issue, right?
Exactly.
Okay. I just wanted to make sure I had that correct in my head.
I appreciate that. So just very briefly again on that first point to clarify after that timeline, my argument here is that the trial court expressly relied on 3112, which was the only authority that State Farm cited, arguing that those charges should be dismissed. That statute expressly requires payment, and liability is only discharged to the extent of the payments. But there was no payment in this case. It has to be money in the context of this statute, regardless of State Farm's position that a dictionary definition should apply, because a dictionary definition, including anything other than money, would render that phrase to the extent of the payments entirely nugatory. Second, as a distinct challenge to the trial court's order, I'm not going to get into the specifics, but I am contending that the contract is ambiguous as to whether the injured person even purported to release her right to benefits that had not yet been incurred. It's repeatedly limited to past and present claims. The language is inherently contradictory, which necessarily makes it ambiguous, and that ambiguity must be construed against State Farm as the drafter. And finally, we only get here if the court does find that liability was discharged under 3112 and that Ms. Jackson plainly waived her rights to future incurred benefits. So we don't necessarily get here, but ultimately this is sort of the crux, and I believe as we sit here today that it is an issue of first impression, at least in the Court of Appeals. As part of the, I guess, As part of the no-fault reform, the legislature added in 2019, the legislature added a direct, independent, statutory cause of actions for PIP benefits in favor of providers who treat a no-fault claimant. Since that amendment, this court has repeatedly concluded that even where an injured person loses her rights to benefits, providers are not necessarily out of luck. In fact, as cited in my brief, this court has published 2 opinions where the injured person has lost rights to benefits through fraud, yet the providers are still able to recover. And essentially, this is a big distinction. It does come up only because of the statutory amendment. Before June 11th, 2019, provider claims were derivative. Even before Covenant, they were derivative. They were dependent on the injured person being entitled to benefits. Then the Supreme Court comes along in Covenant and says, well, you don't have a right to sue in the first place. So providers started getting assignments. Obviously, you can only assign the rights that you have. So an injured person owned the rights to the benefits and assigned a portion of those rights to the provider. So even in the post-Covenant era, pre-amendment, provider claims even premised on assignment were derivative in nature. This court now, specifically because of the amendment to 3112, has stated expressly no longer are provider claims derivative of injured person's rights to benefits. That's the Mota Peguero case, it's the Van Dyke Spinal case. So ultimately here the question becomes, can an injured person waive a provider's statutory cause of action? There is no law supporting that argument, very simply. And because the provider owns that statutory cause of action, the injured person cannot possibly bind the provider, even by purportedly releasing future benefits, because my client's right is statutory. It is not derivative of the injured person's rights. If the court has any questions, I'm happy to answer.
Any questions? Thank you, counsel.
I'll just reserve a few minutes for rebuttal. Thank you.
Yes.
Good afternoon, Your Honors. Nathan Schubarth on behalf of State Farm. I'll make this really brief. And for all the threads of argument the brother counsel talked about, I think this boils down to a really simple question. Can a medical provider pursue PIP claims for services after the injured insured individual has executed a global release with futures included that releases all future claims? And I think the answer is no. 3112, which brother counsel has talked about extensively, he's represented that it creates a statutory cause of action. And I would assert that that's not 100% accurate. 3112 gives them an independent standing to sue, but that still requires that they have a relationship with a injured party who has that fundamental right to bring a claim against the insurer. So it gives them standing, but it's as a standing issue, it's not a substantive right to bring the action.
Well, counsel, didn't the release carve out the ability of other providers to claim future benefits? As a matter of fact,
It did not, Your Honor.
what was the carve out then? Explain that to me.
The carve out in the release?
Yeah, I thought there was reference to a carve out in the release where
To the existing provider claims. So
Okay.
so the timing on this, I think, is really important too. And Your Honor asked that question, and the timing on this is she's injured in 2019. She brings her own lawsuit that goes to verdict, and ultimately the parties settle. While that case is pending, Zaki Anesthesia brings their own lawsuit for existing claims. And that case remains pending when that case settles. There are 2 dates of treatment that are at issue here. Both of those dates are after the global settlement with the underlying injured party. So Ms. Jackson settles. She settles all futures. She settles all future provider claims on behalf of herself, on behalf of anyone who could bring a claim. And then she goes back and she treats with Zaki after that. So she treats after she agrees to waive all claims, any potential future claims from this. The import of this, I think, is really important. If you have essentially, it would never be possible to create a final settlement if brother counsel's argument is accepted with respect to PIP.
If your client was aware of the claims, through the other lawsuit, why was there not a global settlement then brought up? If you say you want a complete release, you were aware of the other lawsuit, you were aware of this provider, you were aware of the relationship with your insured. Why were they not a party then, or required to be a party, to effectuate a full and complete knowing release of all claims?
Because we're talking about future claims. She released all of her existing claims. Zaki had their own separate claims, but these claims did not
But I thought you
exist.
said they didn't have a cause of action.
They do, as to the existing claims, but these are claims that didn't exist when the settlement was reached. So she settles and says, I'm not making any future claims.
But the lawsuit existed prior to the claims being released, right?
A lawsuit by Zaki existed, but each time that they treat her, that would be a separate cause of action that they would have to bring. They could bring it into the lawsuit if they had the right to do that, but she didn't assign it. She released away any future claims. She reached a settlement. She released away any future claims on behalf of herself or any providers.
But I thought the 2008, help me understand how the 2019 amendments fit into this, because brother counsel explained to it, it was to address this derivative claim, and it was to get rid of, hey, we've got to get before we do treatment, you got to assign all your claims to us. The amendments were, my understanding, correct me if I'm wrong, to address that. It seems to be you're arguing, well, they didn't have any of that, so therefore they're just out of luck.
That's not what I'm saying at all, Your Honor.
Okay.
They have an independent cause of action with respect to benefits that can be claimed under an insurance policy. But when she released all claims under that policy, there's no future claims that can be brought under that policy. So,
But at the time your client executed that release, it was aware that a provider was providing benefits and seeking reimbursement for those benefits.
they had provided benefits and they were seeking reimbursement for those benefits. We were aware that multiple providers had provided services to her. She chose to release all future claims.
Well, your client also chose, didn't they, this gets back to the carve out. Your client also carved out some providers, right?
Because they had existing claims. Yes. So they had existing claims,
But if the case hadn't solved, didn't Zaki have existing claims then? Because the lawsuit was filed?
they still do, Your Honor. They still have all these claims for dates of service prior to Ms. Jackson's release of all benefits under her policy. She settled.
And you're not disputing, but you're still disputing the entitlement of Zaki to those.
No, well, those claims are subject to litigation. They're not part of this appeal. All that's at issue in this appeal are these 2 dates of service that occurred after this global release by Ms. Jackson. That's all we're talking about here. They have all their claims in the underlying lawsuit. Those have not been dismissed. Those are subject to ongoing litigation in the Washington Circuit Court, but those are still pending. Those remain active because those claims were incurred before Ms. Jackson released all claims, including all future claims under her policy.
But didn't she release all past claims too?
She did.
So why doesn't that then undercut their claims for the benefits that arose prior to your release?
Because they had an independent right to bring those claims. They brought them, and those claims remained pending. That's why there was a carve out for them and for other providers who had existing litigation prior to her release. Essentially, under this logic, you could have claims that are, you could have a global release with the plaintiff. You could have a provider pop up 5 years down the line and say, well, I treated them and there was an existing policy. And then we would somehow be on the hook.
But that's a different case. That's a hypothetical that's not before. In this case, you had people with notice of both the provision of services and of claims pending, and you still move forward with the release.
As to future claims, that release carved out those existing claims as to Zaki.
Okay.
I'm happy to answer any questions.
Any other questions? No. Thank you. Thank you for helping. me understand that a bit more. Mr. Payne, brief time for rebuttal.
Very briefly, I do want to point out more of the timeline. State Farm appeared in this action, Zaki versus State Farm, in September of 2022. The release was not executed until more than a month later in late October 2022. And State Farm didn't notify plaintiff, didn't carve plaintiff out, had the bills, had the records, had not only the written notice of a claim to preclude liability discharge under 3112, but was in fact sued and had appeared in this action before this release was executed. And then finally, to answer Brother Counsel's question very directly, under the law as it sits today, yes, a medical provider can pursue its direct statutory cause of action, regardless of what other claimants for that claim waive or don't waive or claim or not. And while I can appreciate that this leaves open the fact that an injured person can't waive all providers' benefits, it might be a minor administrative procedural issue, but that's not only what the law is, but also I want to clarify Brother Counsel's suggestion that a provider can pop up out of the woodwork 5 years later is directly contrary to the limitation periods applicable to these claims, which is extremely short, being only 1 year. So ultimately, State Farm had written notice of Zaki's claims before they even, and were in possession and had appeared in this action before Ms. Jackson purported to waive Dr. Zaki's claims. Legally, she didn't have the right to do that. Legally, State Farm did not discharge its liability. And of course, plaintiff can continue to pursue its direct statutory cause of action because none of this has obviated that right. That's all I have.
Can I just ask one follow-up on the carve out? Do you agree that Zaki's pre-release claims were carved out when they entered into that settlement agreement?
No, I'm looking at the release right now, page 2. There are 5 providers listed, technically 6, but two are in the same bullet point. And Zaki is not listed. Zaki is not mentioned in this release whatsoever. And State Farm not only had written notice of her claim through the bills and records, as I've explained in my brief, they appeared in this litigation before this release was executed.
But do you agree then that this appeal only relates to the post-release claims of Zaki?
I do, but only because that's what the trial court ruled. The challenge is only to the post-release dates of service because Judge Connors did not dismiss the pre-release dates of service.
Nothing further? Nothing further. All right, thank you. That case will be submitted.
Thank you so much, Your Honors. Have a great day.
That brings us to our next item, number 12. Case number 373540. Bunkelman v. Lara. Counsel, please approach and state your appearances for the record.
Good afternoon, Your Honor. Michael Smith on behalf of Appellant Brandon Bunkelman.
And Breitmeyer, Assistant Attorney General, on behalf of the Department of Licensing and Regulatory Affairs.
Thank you. You may proceed.
May it please the court. I do not anticipate this being a very long argument, but I would like to reserve a little bit of time for rebuttal, 2 minutes. This is a straightforward case about statutory interpretation. It's whether the agency can replace the word or with the word and in MCL 338-2156-4. That statute, which has been cited multiple times in our briefs, creates 2 independent paths for a journeyman license for an elevator business. One for supervisors and one for mechanics. Mr. Bunkelman undisputably satisfies the supervisory path. The agency denied his license by adding requirements that are nowhere to be found in the actual language of the statute. We're simply asking the court to reverse the motion for reconsideration that was granted and enforce the statute as it was written. Here, the plain language controls. The statute shall be issued if someone passes the written test and has 3 years of experience as a supervisor or 3 years of experience in the mechanic type roles. The legislature used the word or and not and that choice matters. There's a supervisory track and a mechanic track, and the agency collapses these two into one by requiring field type supervision, which defeats the supervisor track entirely. The core legal error here is that they inserted either direct supervision, day-to-day work, field work, none of which appear in this section of the statute.
But it says a supervisor of elevator construction or service.
Correct.
Right? Now, who can perform the elevator construction or service?
Mechanics.
Okay, but licensed journeyman, right?
Correct. Or someone working directly under a licensed journeyman.
So it's got to be a licensed journeyman doing the work or other individuals under the supervision of a licensed journeyman.
To perform the work, that's correct.
To perform the work. And what evidence was presented to Laura or Laura ignored that it was that your client had 3 years continuous service directly or supervising the work?
And that's two separate
of a journeyman.
And the evidence is that he had supervised journeymen. He had 10 years experience with ThyssenKrupp and I believe 3 years of experience with Cone before that.
But weren't those sales positions?
One of them was a sales position, but
Okay,
a lot
so
of
let's
them.
take that out because that doesn't count.
He still had over 3 years experience.
Would you agree that the sales position doesn't count?
Correct. That is part of his job, but is not his whole job.
Okay.
And
Now what about getting to the administrative part? Do you agree that there's a difference in the briefing on whether this is a contested case or not? It doesn't appear to me to fit into the contested case category. That the hearing in front of the board or Laura wasn't a contested case. Would you concede that?
I will concede that, yes.
Okay.
Going forward, the legislature, we cannot insert phrases like direct supervision or day-to-day service. And in fact, the legislature made the choice not to put those in there. And we can infer that because earlier in this same statute in 338-2151, they used the phrase where you were just talking about. They use immediate supervision when talking about who can perform the work. They say to perform work on an elevator, it must be a journeyman or somebody under their immediate supervision to do so. So if they know to use the word immediate supervision or the word immediate, when they want it to be immediate.
What does your client need the license for? If he can't, the license and the relief you're seeking is a limited license, which he didn't ask for. He wanted a broad license that would allow him he wants a journeyman's license.
And
which would allow unlicensed people to work for him, doing the direct work that he's never done any of the direct work, right? He's only supposedly supervised it. And even though that work says, the statute says the unlicensed individuals, the mechanics and the helpers, they can't do that work unless there's a licensed journeyman immediately supervising them.
And the statute, the way it's written, actually solves that problem because he's not doing the immediate supervision. A licensed journeyman would have to do the immediate supervision on site. So there's not some instance.
So what does he need a license for?
Certain clients.
Because if you're asking him to then just supervise journeymen, you're saying the only thing he could do then is supervise journeymen supervising other people. Why does he need a license? He's doing it now.
And in this business, there are other reasons why you would need a journeyman license, including pulling permits or submitting bids. Some clients require you to have a journeyman license to submit a bid, which is something that he does in his role. And he will have to have somebody else do it if he cannot do it as a journeyman. So, and that's why they created this separate track, because there are reasons to be a supervisor journeyman.
Where's the term supervisor journeyman?
The fact that there's two separate tracks.
So that's not defined. That's a term
Well, the term journeyman is defined in 338, I believe it's 251, 2151. And it says someone who is licensed to supervise or perform maintenance. So even there, they recognize two separate types of journeymen, a supervisor or someone who is performing the maintenance.
But you'd agree your client isn't qualified to supervise the mechanics and the helpers.
I would
to
not agree with
provide
that.
direct supervision?
I would not agree that he's not qualified to do so. But I would agree that the board has the right to limit his license
Do they not
and say
also-
that he cannot do that he can only have a supervisory.
Counsel, let me ask you this. Is it under the statutory scheme, isn't it Laura gets to evaluate and review an applicant's background and experience and come to a conclusion based on that? They say and not even a legal conclusion, a factual conclusion. Do you have the experience of supervision as required? You're not asking, does he have supervisory experience of, I don't know, McDonald's working fries? Does he have the proper supervisory experience under the statute? And they make that factual determination. Is that correct?
I don't agree that there's much interpretation to be done based on the clear language of the statute. I think that they certainly can, they are the ones who decide.
So
if
they
the
don't
statute-
have any authority to sort of go behind what's written on paper?
Correct. They cannot change the statute the way it's written. The
No,
way-
no. An applicant. You're saying that Laura or the board, the elevator board, doesn't have the authority under the statute to ask an applicant, explain to me what you did on a day-to-day basis when you list this type of experience.
They absolutely can ask those questions.
Okay, do they have the authority then to make conclusions based on that and say, this experience doesn't meet the proper supervisory status?
Yes, they can make conclusions.
Okay, they make that conclusion, and then if it gets appealed, what is the standard of review?
That first it goes to the elevator supervisory board.
Right, I understand that. I understand the process.
Okay.
I'm saying, what is the legal standard of review? Is it arbitrary and capricious?
For the circuit court's review of it,
yeah.
I believe it's
circuit
whether
court's
there's
review.
palpable error.
Okay.
And here Judge Hattie found that there was, and then he was reversed on a reconsideration.
Yep.
Saying that he made a palpable error when really it was just finding a different result with no new evidence. And there was no palpable error because he just interpreted the statute the way it was written. So going back to your question though about whether they have the right to determine whether someone meets the qualifications. Absolutely they do, but the qualifications are set forth in the statute and they can't deviate from the statute. They can't make up new qualifications. They can't say supervision means day-to-day supervision or on field or field supervision because it's not in there. And the correct remedy, if we think that that's a bad idea, that the statute is wrong, the correct remedy for that is to change the statute, for the legislature to change it. And perhaps this opinion will end up on somebody's desk and that might happen, but our job is to interpret the statute the way it is written.
Don't we also have an obligation to interpret the statute as a whole and understand the statutory scheme and its intent? I mean, my understanding of the statute was it was to provide licensing and supervision to make sure that people that are working on elevators, so they don't just fall out of the sky and cause death, that they're trained and properly licensed to be able to do the day-to-day work.
Absolutely, and the
Okay.
statute does.
And that's what the statute does. So you have to read all that together to further that intent. Is that correct?
You do have to read the entire statute to read its context, but the entire statute throughout creates two separate tracks for a journeyman license, one for supervisor and one for mechanics. And policy considerations, safety, things like that, those don't overcome the plain meaning of the statute, just the words that are on the paper.
Well, doesn't the statute plainly say the license shall be issued, comma, after approval by Laura?
Yes.
And there was no approval by Laura.
After approval by the board. But then it states what constitutes approval by the board. And that states a passage of a written examination, which there's no dispute, Mr. Bunkelman passed the written examination, and 3 years of experience as a supervisor in elevator construction.
After that is evaluated by Laura, and they said no.
No, I believe that it's the other way around, that it shall be issued, and then it can, and here is the context of how it
says
shall be issued.
Elevator license shall be issued, comma, after the approval of the board and after an applicant successfully passes the examination. I read that to say the license shall be issued, but only after Laura determines that there's proper level of 3 years experience.
In there, it says, it doesn't say proper level of 3 years experience. It just says 3 years experience, continued employment
Well,
as a
earlier you
supervisor.
agreed though that they had the ability to look at a person's written submission of their experience and evaluate that to make sure that it's not 3 years serving fries at supervisory experience serving fries at McDonald's, right?
Correct. It has to be 3 years of continuous employment as a supervisor of elevator construction or service.
And then that decision gets reviewed for your standard at least, and we can see if council agrees with that is palpable error. Whether Laura's conclusion on whether or not the experience meets the standards is for palpable error.
In any event, for our purposes, we are looking for palpable error, or the reconsideration order needed to find palpable error, and I don't believe that they did so in that case.
Okay.
And really, this case is not complicated. It is, the statute says or creates 2 tracks, one for supervisor, one for a mechanic. And that single change is the difference between eligibility and denial here. Mr. Bunkelman satisfies the statute as it is written. And we respectfully request that the court reverse and remand with instructions to issue the license subject to any lawful restrictions that are requested.
But just to clarify, your client, when he applied, he didn't request any restrictions. That was sua sponte issued by Judge Hattie, right?
He didn't request it when he applied. It was brought up during the elevator board of appeals, but it was not requested at the initial application. Although even that, it states that the board may do that. It is, the license shall be issued.
Mandatory.
Correct. That the license shall be issued. That is mandatory if he meets these requirements, and they may issue a restricted license if they choose to do so. And again, that goes back to your question of why would somebody need this license if they're not doing that? Obviously, if restricted license are contemplated by the legislature, they're contemplating people who don't work necessarily on these elevators having a journeyman's license and having it be restricted.
But
Otherwise,
I think isn't a fair reading that it'd be restricted to, there's like 8 different categories of work done. You know, it's a helper, it's a mechanic, it's an operator, I don't know, you guys probably know all the lists, but I'm just going off the top of my head.
That is a fair reading of it as well.
Anything else?
Thank you.
Anything else? Well, I should say anything.
Good afternoon, and may it please the court. Assistant Attorney General Kim Breitmeyer on behalf of Appali Lara, and with me at council's table is Assistant Attorney General Gallantfish. Your honors, here in Michigan, Lara's elevator section is responsible for ensuring elevators are installed and maintained according to highly technical national safety standards, rules, and statutes designed to protect the riding public and those who perform work on elevators. Part of that task involves ensuring that individually licensed elevator journey persons and elevator contractors meet minimum education and experience requirements that are set forth in 2 different statutes, the Elevator Safety Board Act, the Elevator Licensing Act, and then the associated elevator rules. Importantly, as your honors pointed out, MCL 338-2155 sub 1 requires that the work of installation, alteration, maintenance, repair, servicing, inspecting, adjusting, or testing an elevator be done by a person who is licensed as an elevator journeyman or by his helpers under the immediate supervision of a licensed elevator journeyman. Combined with elevator construction work, these tasks will be what I refer to throughout my argument as elevator field work. None of these tasks may be performed, nor may their performance be supervised within the meaning of the statute from an office setting. Bunkelman agrees that he should not be personally performing elevator field work. However, it is important to remember that the Type A license that Bunkelman sought would permit him, a person who has never constructed an elevator from scratch, to do just that. I would like to use my time to cover 3 reasons why the agency reached the correct result here. The Elevator Safety Board and Lara's elevator section were legally authorized and qualified to assess the nature and relevance of Bunkelman's education and experience.
How is that? We agree with that, or let's say we agree with that. What's the standard of review?
Yes.
Of that determination?
So the decision is whether the decision was authorized by law, whether it violated the state constitution, was in excess of the agency's statutory authority, made under unlawful procedures resulting in material prejudice, and most importantly, whether it was arbitrary and capricious, whether it was freakish and whimsical, not just whether the decision was objectively correct. We also think there's a mixed standard of review that applies to this case because there is the matter of statutory interpretation here. And so there is de novo review of the interpretation of the agency's own statute. The argument here centers on whether the final decision was arbitrary and capricious. Although the enabling statutes and rules do not afford a contested case hearing to an applicant initially denied a license, they do empower the Elevator Safety Board to hear and make recommendations in response to written appeals.
I'm sorry to interrupt, but do we need to reach the statutory interpretation if we find that Laura's determination, factual determination that the experience was lacking or didn't meet the statutory requirements? Do we have to meet that, or can we say it's not arbitrary and capricious without reaching statutory interpretation, or do we have to do both?
I think that conclusion may be reached without reaching the statutory interpretation argument, because here we're arguing the plain meaning of the statute read together with the rest of the Elevator Licensing Act and the rules leads to the conclusion that the elevator journey person has two roles. They supervise unlicensed individuals, helpers, who could be, in the industry terms, they could be apprentices, they could be elevator constructors or mechanics, or they can perform the field work themselves personally. So in order to have both of those roles, the person must have the requisite field work experience, the 3 years of continuous experience.
And in my understanding, under the rules implemented under the APA by the board, is that there's 4 types of licenses?
So there are 3 classifications. I'm sorry.
Type A, B, and C?
Correct.
And under type A, B, or C, are any of them supervisory licenses?
No, they are not. There is no separate supervisory tract or field work practice act. So no separate journeyman, mechanic, however you want to phrase it, or supervisory. There are just different classifications, A, B, and C. A being the broadest that allows everything that you would do with any type of elevator. And then B being just repair and maintenance work, and C being specific to the device. So you can perform work if you pass an exam specific to that device.
Any other points? I know you stated you had 3. What are the?
Sure. Moving on from the standard of review, I did want to also address briefly the issue of the restricted license, because that has been an issue. Circuit Court Judge McGivney correctly vacated the retired Judge Hattie's March 2024 order because the license was restricted to supervision just simply doesn't exist in the statute and rules. The Circuit Court initially granted Bunkelman a license that restricted him from doing the quote actual construction or repair of elevators, even though both parties agree that he applied for that type A broad license that would enable him to construct, repair, install, alter, and maintain any type of elevating device. He first raised that argument, as was mentioned previously, that he was entitled to alternate restricted license during oral argument before the Circuit Court on appeal. And generally, an issue is preserved only if it is raised or addressed by that body that issued the final decision being appealed. So thus, Judge McGivney correctly concluded that the Circuit Court's scope of review was limited to Lara's administrative record. The Circuit Court also properly determined that Lara's motion for reconsideration, and this is where the palpable error standard comes in, should be granted. And Judge Hattie's order vacated when it found that the prior judge's order contained demonstrable palpable error. Judge McGivney based his determination in part on the fact that Bunkelman does not meet the qualifications for an elevator contractor license, the only license type authorized to submit plans and specifications and pull elevator permits under the enabling statutes. In addition, Lara's director exercised his right specified in MCL 338-2156-4 to restrict the license to specific types of work through the promulgation of Rule 408.718.1. That sets forth those three classifications of elevator constructor and contractor and elevator journey person licenses, as we previously discussed. And thus, unless the court has any questions, I'd like to conclude my response. In response to the agency's motion for reconsideration, the circuit court applied the correct legal principles by showing deference to the agency's conclusion, informed by the Elevator Safety Board's recommendation that Bunkelman lacked the nature and quality of experience and education necessary for him to obtain an elevator journey person's license. As a result, we ask that the court affirm the decision below. Thank you.
Counsel. You have time for rebuttal?
Just briefly, Your Honor.
That's what they all say.
I promise. The statute creates two tracks. It has the word "or" in it. If they don't want to have two tracks, if they don't want to have a supervisor track for journeyman, they should change the statute, not rewrite it judicially, not rewrite it through the agency. That is all I have to ask.
How do you define, because I don't, how would you define a supervisor of elevator construction or service?
Someone who,
that's not defined, right?
someone who supervises the overall, oversees it, who oversees elevator construction or service.
But you'd agree that in order to have service done in compliance with the statute, it requires a licensed journeyman to supervise it.
It requires a licensed journeyman to perform the work or supervise someone. So there could be a scenario where the supervisor does, and this has happened many times, where there's a supervisor who does not have a journeyman license, but the people performing the work are journeymen.
Right. Okay. So your position is if there is 3 years of supervising journeymen who are supervising work, then that meets the supervisory requirement.
Or journeymen who are just performing the work. It's not always a scenario where there's an apprentice under a journeyman.
But doesn't that presuppose then that the journeyman's, the supervisors supervising journeymen are actually on site supervising the work being done?
For the section 1 of the statute, absolutely. And that's why it says immediate in that section. With that, I'll conclude.
All right, but you don't disagree though that they're in the regulations passed by Laura, it's limited to those 3 types of licenses and as described.
I do not know how many different licenses that they have, but I don't see why they cannot restrict, they're not restricted in this statute from putting further restrictions on someone.
But you don't have any dispute with Sister Counsel stating
not.
that there's A, B, and C licenses,
I do
and none
not.
of them contain
I don't dispute
supervisory
that.
license.
No.
Okay. All right, thank you. This case is submitted. Who would have thought the elevator board would be as interesting as it is? Makes me question every time I get into an elevator. That case is submitted. Now moving to item number 13, case number 376301, Coolidge v. Henke. We have a request for oral argument that has been granted for Miss Coolidge. Do we have Miss Coolidge on the line?
I am here, Your Honor.
Okay, give us 1 moment. There we are. We've got you. Now, I don't know if you had an opportunity to listen in earlier, but let me just give you a little prelude to some things that we said. You're going to have your time to tell us everything that you need to tell us about your appeal. I do want to just focus, let you know, we've reviewed all the briefings. We're very familiar with the facts. We understand your argument. So if you could please, focus on the real salient, most important facts and why you think the lower court got it wrong and what's important for us to hear. And with that, you may proceed. Please state your name for the record, and then you may proceed.
May I please this court, Samantha Coolidge appearing pro per.
I have nothing to add to my brief today, and I would welcome any questions that your honors would have today.
I don't have any.
Let me just check my notes. I think I'm good as well, but let me just confirm, ma'am. No, I think that takes care of it. This case will be submitted.
Thank you very much for your time, your honors.
All right, thank you.
Thank you for hanging in there.
No problem. Have a good rest of the day.
All right, you too as well.
Thank you.
The remaining cases do not have any counsel submitted or appearing for oral argument, but let me call them and submit them on the briefs. Item number 14, case number 377205, In re Goodlow Minor. That case is submitted on the briefs. Item number 15, case number 377030, In re Millard Birmingham Minors, and that case will be submitted on the briefs. With that, that concludes our day one of this case call for April in Lansing. We appreciate everyone's time being here, and we look forward to seeing everyone tomorrow. Court is adjourned, and I let Juan do his thing.
All right, Jim.